Big pardon, madam. He is admission, my lord. But without giving any notice, my lease has been cancelled and imposed fine market. Written. Honorable pardon. Raised admission matter. Challenging order of non-travel. I file a requisition. No listed.
Contempt matter. Contempt.
Pardon. First contempt. On face review petition, your lordship will justice share the procedure. And one is against right for life. I am custodian for around 5 years. LCR has already come, appeal is admitted. Legal. I can put it in. Yes. And then one matter, under least item 37.
Supplemental.
You want to mention?
Yes, item 37.
No, we are in yes, item 30.
Supplementary list item 37.
Yeah.
But my friend is there. Government and the department has filed 2 counters. Yesterday, I got a recent copy. One has come to your lordship board, I think. The other one has not come. But, I would like to file a rejoinder.
Who is in charge of this item number 37 from the states? Just call him for that. What do you want, Mr. Mishra?
To file a rejoinder. Yesterday in the evening, I got a copy.
It is in the cause list. It is mentioned that counter affidavit by opposite party number 6 is at flag C.
Yes.
Another counter.
One has come. The other one has not come.
Who has filed that counter?
I think
Department of Tourism. No,
Opposite party.
opposite party number
two.
I just read opposite party number. Consolidated restriction. Department of Tourism is opposite party number. All right. So I appear for opposite party number 7. Okay. Mr. Mishra and senior advocate appearing for the petitioner submits that he has received the counter affidavit filed by the opposite party number 6, which is at flag C.
2 and 6 both.
Separate counters or?
And another counter affidavit filed by opposite party number 2 yesterday, and intends to file rejoinder affidavit to the said counter affidavit. The counter affidavit filed by opposite party number 2 be placed on record. Mr. Patnaik and counsel for the opposite party number 7. Opposite party number 7 is present. We have also received the counters. And he submits that he has also received the counter affidavit filed by the opposite party number 2 as well as opposite party number 6. So we can take up a week after.
24th, my friend was suggesting.
24th of February 2024.
There's an interim order.
Please this matter. We are recording also the presence of Mr. Nayak Partha. Yes. He has come to the court now. Yes. Mr. Partha Nayak and counsel for the and additional government advocate is present. This matter will be commencing from 24th of February 2025. The result affidavit, if any files, we handed over, copy of will be handed over to the land council for the respective parties present.
My lord, it will come on 24th.
24th is
Again, 24th. Interim order to continue.
interim order is the first one. Continuation. Yes.
Supplemental list, item 13,
Item 13 minutes, the office party number 2 is on VC.
What will be party number?
Office party number 2 minutes, Sri Priya Parimon Mishra. So working as
My lord, I am here.
yes, ma'am.
Sir, my lord, I am here.
Engineering in Chief Electrical cum Principal Chief Electrical Inspector Odisha.
Just give it in writing.
Yes, ma'am, we have given it. And
So-
once the Lordship's order has been compliant, we have filed a compliance affidavit. I have served a copy to my learned seal.
Where have you stated that? Which paragraph? You have received the copy?
Just now, my lord.
Just see that paragraph.
Nice. Para 12, 13 minutes. 13 minutes.
Para 13.
Yes. Page 5. Page 5. The pension paper of Sri Ramesh Chandra Sahu have already been submitted to the accountant general Odisha Bhubaneswar through online on 6/2/2025 by ACE cum PI Keonjhar Office Partner 3 for immediate sanction of the pensionary benefit in favor of the petitioner, and the copy has been annexed as Annex E by 2.
So 6 means you have done after this order was passed.
Right.
Just last week you have done it. How much time it will take then again?
Its finance department's concurrence was required, was supposed to be sought for me. Like
And the order is very clear. The Honorable Supreme Court has stated that we are not inclined to interfere with the improved judgment. However, the order passed by the High Court be implemented within a period of 3 months. That 3 months have already expired. 3 months means from the date of the order of the Honorable Supreme Court. The order of the Honorable Supreme Court is 16/7/2024.
process start करो.
Yes, sir.
हाँ,
But so the rotated 31/2025. Nada लिखी दे दो. Yeah. And designation we have taken.
Yes.
Mr. Parimon Mishra, Engineering in Chief, from Principal Chief Electrical Inspector, is present through virtual mode. Compliance affidavit has been filed by the Superintending Engineer from Deputy Electrical Inspector Keonjhar. They charging a copy on the Land Council for the petitioner, wherein in paragraph number 12 and 13, it is stated as follows. These 2 paragraphs. Since the order has been complied with, the contempt petition is disposed of. Personal appearance is dispensed with.
Thank you.
rectification code.
This is
Four to five.
rectification record.
Record. They used to scan and incorporate in digital record. Then our job disclosure case CORAM.
Scan for the recorder of the record. So line term of the
Disclosure.
Thank you, your lordship.
So dispensary personal appearance.
Item 1.
Issue original annexure 6, relevant page 24.
1196.
Case of the petitioner matter. The petitioner is the owner of the land matter in this mill. That is the annexure 1 matter. The entire land of the petitioner has been acquired.
There is an order on 4723.
That is the order.
You have to produce the documents.
I have filed that. Sir, notification.
Each legible copy would have the that defects.
Memo.
Along with gazette notification 9.
Notification.
Defect number 11 is page 14, 15, 17, 25, 26, 30, 32.
That defect I have not removed, but as per the order of this announcement, I have filed.
Now you come to that relevant order, that is annexure 6, which you are challenging.
That is the page 24. Relevant page 24.
When you come to page number 23, where it is mentioned as case history and disposal order.
The major settlement error Khatian number 15 of Moja, Singriguda, was recorded in the name of Gopalananda Pradhan, son of Satrughan Pradhan, Devanand Pradhan, son of Gaurang Pradhan, Govardhan Pradhan, Porshudhar Pradhan, son of Satyavadi Pradhan. An area of 5.18 acres land, Khatiana number 15, was notified under section 4.1 on dated 14/6 to 1986. Under section 7 to
4.1 notification is dated
14/6,
1986. Okay, then
under section 17.1 on dated
7.1 notification hochi
2/4/88.
Yes,
1991 notification dated 14/4/90.
9.1 alla
14/4/90 by the Central Government of India and Gazette of India by vesting the government company under section 11.1 dated 9/10/91. During the address of the land, the trees and house structure standing over the acquired land in the year 1992, one Hara Pradhan had submitted a registered settlement letter by the registered number 1064 dated 16/4/1956. On the basis of said settlement letter, Hara Pradhan claimed 0.65 acre of land out of Khatian number 15, but later it was found that out of the said 0.65 acre of land, he had already sold 0.63 acre of land, which includes selling of land to his own sons, namely Viresh Pradhan, Rajesh Pradhan, the present petitioner before Lordship, and Umesh Pradhan. After 4.1 and 7.1 notification,
this is most important.
Notification, leaving only 0.02 acre of land out of the acquired area. The present petitioner had purchased an area 0.15 acre of land by registered deed number 1441 dated 22/89. Subsequently, Sri Rajesh Pradhan muted the said land in his favor in Khatian number 74/84.
Your purchase
I have admittedly purchased the land after 7.1 notification.
4.171 notification. Yes, then
that the Sri Rajesh Pradhan, who is a younger son of Hara Pradhan, also claimed employment against his purchased land measuring an area 0.15 acre and the balance land share of his father measuring 0.02 acre out of Khatian number 15. Next matter. As per the guideline issued by the government of Odisha by number so dated 24/1993, the employment opportunity need not be given to the person who purchased the land after notification of under section 14.1 of the land. Hence, the Rajesh Pradhan is not eligible for employment against the land recorded in his name
in the MS Khata number 74/84 of Mauja Chingrida, he had purchased the land after 4-1 and 7-1 notification. And against the balance area, the 0.2 acre land Haro Pradhan, one of his nominee sons, namely Umesh Pradhan, has already been extended employment benefit. Family members of Haro Pradhan or any one of his sons, family were not residing village Chingiriguda. No house structure has been acquired from them by the MCL in village Chingiriguda or any other village acquired by the MCL. Hence, the Haro Pradhan of his families are not a project displaced family. They have referred the circular, that I have annexed the answer 7. That circular, relying on that circular, that they have rejected my referendum, my claim, grievance. My humble submission before a lordship, my lord, admit that at the time of accord, my lord, there is a family. As per the rehabilitation resettlement policy, my lord, is a family. Family is defined, my lord. Lordship, I have annexed that is answer 8, my lord.
No, the
Admittedly, I have
the reasoning which has been assigned
my lord,
in this impugned order, that is 12/1/2023,
my lord,
right?
my lord.
So, what is the illegality in that? order?
Illegality, my lord, that is true thing, my lord. Admittedly, that is I have purchased the land after 7 notification, my lord.
Then
I have purchased, but my entire land has been acquired well. They have not given any single part till that, my lord. Though the land has been acquired since long, my lord. They have not.
Father will get.
your
No.
father,
Father, I am the owner of the property. How can my father get that?
no. It is no question of you are claiming employment, not no.
I am not mentioned also the compensation amount.
No, you are not doing grace to a buyer. You have your specific thing is that you
The
have
employment.
not you are to entitled to that employment, right? But they have stated the reason has been assigned that since this land has been acquired after so and so, you may not get the employment, but otherwise you are entitled to the compensation. That is not your claim here.
That is not my claim.
So,
My submission before lordship, my lord. The family has been defined, my lord, as per RR policy, my lord, that I have annexed answer 8, my lord.
yeah.
The family that at the time I have the family means, my lord, the husband, wife, and minor son and daughter, my lord. I have the major, my lord. I have separate lordship and should understand.
No. You see, if that particular sale deed date in which that
That
sale
is
deed
admitted,
that is excluded, then so far as your father is concerned, that the person which has not been sold, if that is you, that acre soon
0.02.
So
That my
for
younger
that, your
brother,
father has given
Nomination.
nomination.
Umesh Pradhan, he has got the employment.
Brother, not say the one nominal, your own brother has got employment.
Family means defined, my lord.
How many persons will show us that everybody will get employment? It is the one person who suppose land
In
stands
one family,
Recorded the name of one person.
one person in one family, my lord.
फैमिली माने सेई जो आपनकर से लैंड टाकू जदी एक्सक्लूड कर दिया गला बाकी जदी एंटायर धरा गला ताले आपनकर बापाଙ୍କ नारे से जमी अछि तो बापा जणु को सजेस्ट कले नॉमिनेशन देले सेई नॉमिनेशन जाकू देछन से एम्प्लॉयमेंट
मोर सेपरेट फैमिली हिसाब रे आसी ताले मोर मेजर
सेपरेट फैमिली एइथि पई आपन कहउचंती जेहेतु 41 ये परे आपन जेहेतु आपन को ଆପଣଙ୍କ registered sale deed ଆପଣଙ୍କ ନାଁ ରହିଛି ସେଇ basis ରେ ଆପଣ କହୁଛନ୍ତି. Is it not correct? But the thing is that cannot be taken into account in view of the.
Admittedly, I have purchased the land after 7 notification, but since I have the separate family, my lord,
you will definitely get
the RRM policy. I have no entitled.
Get the compensation amount. There is no dispute about that. But the thing is that about the employment, that is the main argument.
Main argument. That is my main claim before lordship.
So how can you get it?
In fact, to get over that policy, that sale has been done.
That I
but
can.
ହବନି ଆଉ
ଆପଣ ଜାଣିଲା ପରେ କଣ ପାଇଁ ହେଲା ଯେ ଆପଣ ଯଦି ଜାଣିଲା ପରେ ନୋଟିଫିକେସନ ହେଲା ପରେ ଏମିତି ଟ୍ରାନ୍ସଫର କରିଦେଇ ତାଙ୍କ ନାଁରେ ମ୍ୟୁଟେସନ କରିଦେଇକି ସମସ୍ତେ ଗୋଟେ ଗୋଟେ ଚାକିରି ମାଗିବେ
ହେଇପାରିଥାନ୍ତା
subsequent 93 ରେ ये notification ଟା ଆସିଲା ଏ ଯୋଉ letter they have relied on that the annexure 7 ଯୋଉ କଲେକ୍ଟର କୁ ଅନୁଗୁଳ ଆଉ ସମ୍ବଲପୁର ଦିଆଯାଇଛି they rely on that this letter they have
ଆପଣଙ୍କର
otherwise
ପଲିସିଟା କେବେ ଥିଲା କି?
notice
86 ପରେ ପରା
ଆଜ୍ଞା
ପଲିସିଟା କେବେ ହେଇଥିଲା ଯୋଉଟା ରେଫର କରିଛି?
ଯୋଉ coal bearing
policy rehabilitation
rehabilitation 2006 rehabilitation 2000 that is unnecessary 18
সেই ସମୟରେ ଲ୍ୟାଣ୍ଡ ଓନର କିଏ ଥିଲେ?
ଲ୍ୟାଣ୍ଡ ପରେ ଆକ୍ୱାର ହେଲାଣି ସବୁ ଏବେ ପଲିସି ଅନୁସାରେ ଦିଆହବ ଆପଣଙ୍କୁ 1989 acquisition of 8
ଲ୍ୟାଣ୍ଡ ଯାଇଥିବ ସେ ପାଇବ କେମିତି?
acquisition of 86
Brand is
98
one
1990
notification 86 but relying on that that letter that is 93 the government has written to the collector Hon'Ble and Sambalpur that on that basis they have rejected my representation. So let's see for a moment answer 7 page 25 on that basis they have rejected. So 93 they have issued this circular.
When we come to that annexure 7
Answer 7 million to the from say under secretary government to the collector and Hon'Ble oblique Sambalpur inform guideline rehabilitation of the displaced persons oblique families due to SCCL project at Sambalpur and Dhenkanal district. Sambalpur that is at the time at the time the year 94 the Jharsuguda district community force created. At that time they included the Sambalpur. I am directed to say that the government after careful consideration have been pleased to relax the restriction import geo number so and so dated 31 in connection with the uniform guideline for rehabilitation of the displaced person public families due to acquisition of land for mining operation in the district of Sambalpur and Hon'Ble. In the aforesaid geo, it was stipulated that the person may be eligible to get the job under existing policy only if he or his family loses the land which he or his family had at least for 12 years. Now it is decided that a person may be given employment opportunity to who held the land prior to use publication of notification under section 4(1) of the Land Acquisition Act.
এটা আপনার এগেইনস্টে যাওনি এটা যাଉଛି ସେଇଆକୁ ରିଲାଏ କରୁଛି
ଆଜ୍ଞା ଆଜ୍ଞା ସେଗୁଡା ମୁଁ 93 ରେ ଦେଇଛନ୍ତି ତ ସେଇ 93 କୁ ରିଲାଏ କରିକି କରୁଛି।
ଆରେ 93 ପୂର୍ବରୁ ବର୍ଷ ଥିଲା 93 ପୂର୍ବରୁ ଥିଲା ଯେ 12 ବର୍ଷ ମିଳିବ ଏବେ କହିଲେ ନାଇଁ ତା ପୂର୍ବରୁ ଥିଲେ ବି ହବ
ଆପଣ ପାଉନା
ହଉନି।
how you claim there is no illegality we find in that order. The writ petition has been filed by Rajesh Pradhan. Prayer to quash the order dated 12/1/2023 passed by the chief manager so on so on. He is the opposite party number 1 here opposite party number 1 chief manager. Yes. On the representation filed by the petitioner as per the order of this court in WPC number 32321 of 2022. It is the case of the petitioner that MS Khata number 15 and 16 of Mauja Chingiriguda was recorded in the name of his father, late Hara Pradhan, and that apart there was also a joint ancestral residential house at village Chingriguda. Beside the aforesaid property in MS Khata number so and so, paragraph 3 regulatory. The opposite parties notified the acquisition of land under coal bearing areas, acquisition and development Act 1957. And opposite party number 2 issued a notice under section 13 plus 5 of 1957 Act to receive an amount of rupees 3,656 only for the acquisition of the land bearing moja, so and so, paragraph number 4. It is the further case of the petitioner that the entire land and building which was recorded in the name of the father of the petitioner and across from 15 decimal along with the residential building in which the present petitioner was exclusively owner of the land has been acquired by the MCL authorities. And the father of the petitioner made representation to the opposite parties for appointment of the petitioner as land outstay against the land acquired under 1957 Act. It is for the case of the petitioner that the opposite party number intimated him that the employment of the petitioner against acquisition of land in village Chingriguda has not been agreed by the MCL headquarters, Kurla. The petitioner submitted a representation to the opposite party number 4 and since there was no response from the opposite party, the petitioner approached this court filing WPC number 3231 of 2022. This court had order dated 5/12/2022 has been pleased to dispose of the said petition, directing the opposite party number 4 to consider the representation of the petitioner in accordance with law. After the order was passed, the opposite party number rejected the representation filed by the petitioner by the Annexure 6, which is included in this writ petition. The opposite party number so and so 4 has stated in the impugned order that acre 518.18 decimal of land in Khatian number 15 was notified under section 41 on 14/6/1986 and under section 71 on dated 2/4/1980 and under section 91 on 14/4/1990 by the central government in the Gazette of India, vesting with the government company under section 11(1) on 9/10/1991. One Hara Pradhan, who is the father of the petitioner. Your father is Hara Pradhan, na?
Yes.
Submitted a registered settlement letter dated 16/4/56, claiming a person 0.65 decimal of land out of Khatian number 15. But it was found out that out of a person 65 decimal of land, the said Harapadhan had already sold a person 63 decimal of land to his own sons, including the petitioner, after 4/1 and 7/1 notification, leaving only a person 0.02 decimal of agricultural land out of the acquired area. The petitioner purchased a person 15 decimal of land by registered sale deed dated 22/12/1989 and also mutated the land in his favor. So far as the acquisition of a person 0.02 decimal of land out of Khatian number 15 of Mauja Chingriguda is concerned, Umesh Pradhan, the brother of the petitioner, and who is also the son of Hara Pradhan, has been provided with employment benefits as per the nomination of the said Hara Pradhan. The guideline issued by the government of Orissa and dated 24/12/1993 indicates that the employment opportunity need not be given to the persons who purchase the land after notification under section 1 of the LA Act. And since the petitioner purchased the land by way of registered sale deed on 22/12/1989, which is obviously after the 4/1 notification, it was held that he is not eligible for employment against the land recorded in MS Khata number 74/84 of Mauja Chingriguda. So far as the balance share of a person 0.02 decimal of land of the late Harapradhan is concerned, as per his nomination, the brother of the petitioner, namely Umesh Pradhan, has already been extended employment benefits. It is further mentioned in the impugned order that the family members of Harapradhan and his son's family were not residing in village Chingriguda, and no house structure has been acquired from them by MCL in village Chingriguda or in any other village acquired by the MCL. And therefore, neither Harapradhan nor his family members can be said to be project displaced family. Accordingly, the claim of employment of the petitioner was not agreed by the MCL authorities, and the representation filed by the petitioner was rejected. The land counsel for the petitioner placed the Annexure 7, which is the letter dated 24/12/1993 of the government, wherein it is clearly stated, while relaxing the restriction imposed in GO number 5408 dated 31/1992, that a person may be given employment opportunity who held the land prior to the publication of notification under section 41 of LA Act. Stop. The employment opportunity need not be given to the person who purchased the land after 41 of the LA Act. And the other stipulation in the GO number so 5408 dated 31/1992 remain unchanged. In view of the aforesaid letter dated 24/12/1993 and the undisputed fact that the petitioner purchased the land by way of registered sale deed on 22/12/1989, which is after the 41 notification dated 14/6/1986 and 71 notification dated 2/4/1988. And since as per the nomination of Hara Pradhan, in whose favor original land was in existence, the brother of the petitioner has already been extended employment. We do not find any infirmity or illegality in the informed order. Accordingly, the petition being devoid of merit stands dismissed. Lekhidevata Purvur, as per the order dated so and so, the land counsel for the petitioner has filed the gazette notification with a memo, which is on record. Yes.
Item 2.
The state was to obtain instructions.
My lord, your lordship may kindly see order dated 37/2024 after this notice.
Please place that order. Paragraph 3.
Yes, my lord.
Please place that order. Have you got that order copy with you?
Yes, my lord.
Please place. Paragraph 3.
Paragraph 3, yes, my lord. The learned counsel for the petitioners drew the attention of this court to Annexure 1, which is the letter dated 22/11/2023 issued by the opposite party number 3 to opposite party number 2, wherein it is mentioned that the claim of the petitioners is genuine and the petitioners are entitled to for higher compensation under section 28A of the Land Acquisition Act 1894. As per the judgment of the learned senior civil judge Nuapada in LAR number 132 of 2010. Higher compensation award has been made in favor of
Please the next line, next paragraph.
the learned counsel for the petitioner submit that even though the recommendation was made way back on 22/11/2023, but no action has been taken by the opposite party number 2 for disbursal of the amount in favor of the petitioners.
Okay, yes. Then state was asked to obtain instruction.
Yes,
What is your instruction?
We'll wait sent, but no communication yet. May kindly give me until the 25th, my lords, I'll get necessary instructions and do that.
Mr. Nayak, this matter was supposed to be listed on 12/8/2024. So it has come after almost 6 months.
Yes.
Has passed. So you are yet to. Have you communicated this?
We have sent a letter on 3/8. We have communicated.
Get the otherwise that concerned authority will ensure this.
My lord, call this matter for 25th, my lord, before that.
All right, Mr. Nayak, an additional government advocate, submits that the matter may be taken out on 25th of February 2025 so as to obtain instruction in terms of the order dated 37/2024. Stop. Let this matter on 25th February 2025. Yes.
Item 3.
As per the Lordship's order 27/1/2025, I filed the IA for amendment of the writ petition, incorporating the para relevant which are left in the writ petition. So IA 22566.
Have you solved a copy on the opposite parties?
Yes, sir.
Who are the opposite parties here?
1 to 3.
Acha.
Senior, DJ is the
No. Have you received the copy of the interim application? And 1, 2, 3.
Yes.
Then who are appearing for 4, 5, 6, and 7? Mr. Nayak,
My lord.
you are appearing.
I am.
Okay. So, what is the amendment sought for? Amendment regarding, well, after disposal of the writ petition, earlier the direction was given to the petitioner to file a
The
representation.
amendment is
Yes.
paragraph number 25 and 26.
26.
Okay. And also the prayer portion.
Also
No, there
prayer.
is no prayer.
The prayer, it is almost right.
Doctor
My lord, it is not formal in nature. We have to take instruction, my lord. It is this amendment they have filed in additional affidavit. It is not formal in nature. It is a
Okay.
dictum. They have
If
amended
you want to
part of-
file any objection, you can
Yes,
file.
yes, my lord. Yes, yes. Yes.
All right. Let's continue. IN number the five objection many times. IN number 2256 of 2025. The land is an application for amendment of the writ petition. The copy of the interim application has already been served on the Land Council for the Union of India. Opposite parties
I
number.
do not have a copy in my records, my lord. If he has served, my lord, I break that the copy.
Give an extra source. 1, 2, 3. Let a copy of the interim application be served on the Land Council for the state which is appearing for opposite parties number 4 to 7, na?
My lord.
4 to 7. The Land Council appearing for the Union of India submits that some time may be granted to obtain instruction to file objection to the interim application. Put up this matter. Mr. Pari, କେବେ ରଖିବା କୁହନ୍ତୁ 24-25
Two weeks, madam.
Please, this matter will be commencing from 24th February 2020.
Oblige, madam.
Along with କରିଦେବେ ଏଇଟାରେ ବି amendment କରିଛନ୍ତି କି ଦିଟା
ହଁ ଯୋଉଟା ଏକା କରିଛନ୍ତି one case Mr. କାଶୀ ଦେବେ another case ବି Mr.
ଏଇଟା ବି ତାର IA number ଟା ଅଲଗା ସେ ଦେଖିଲେ that names have been given
yes ma'am well provided the list of these councils देखिए ना
ଆଜି ମୁଁ ଜାଣିନି ଆଜି 10:30 ଅଫିସ ଖୋଲା
Item 4.
Order 4 to 25. State must be filed, I was to file an affidavit, my lord. That affidavit is on record at page flat 50.
Bag 50. And you have given a copy to Mr. Guru. Just now. Just now means you want to go through it or you can take up tomorrow. There is no problem.
I'll just take out the review. I had to submit an affidavit. There is an apparent conflict between the instructions given by the Tahsildar and the collector's letter. And I was to submit an affidavit clarifying that position, which is what I have.
No, you just handed over. Let him go through it. We can take up tomorrow.
My interest is for early disposal of my case, man. That's what I have prayed for, man.
No. So do you want to take time for instruction? So we can take it up. All right.
Okay. All right. Then yes,
2 meters. Flat 50.
Yes, earlier he had said it has been disposed of. Thereafter he sent instruction. That is a mistake. I want to withdraw that.
Yes.
now what is your what you have stated in that affidavit which you filed?
There are 3 my lord.
Para 3, yes.
I have explained the various collectors' letter, my earlier letter, and the letter that subsequently given. So, in view of that, in view of the above factual circumstances, the opposite particular number 3 humbly submits as the earlier instruction given to the office of the Advocate General, right, letter dated 24/1/25 may kindly be ignored, and the subsequent letter dated 3/2/25 may kindly be taken on record. The letter dated 3/2/25 of the collector Sambalpur reflects the correct position as regards the current position of OGLS miscase number 29 of 2003, which has already been considered by the authority.
So what is his explanation for giving wrong information to this court?
In hastily has given it on the parent 2, he says the deponent begs to clarify here that in the aforesaid case, a communication was received from the office of the Advocate General Cuttack by letter number so and so, dated 10/1/25, regarding submission of instruction in the matter. The opposite part number 3 misread the same and issued letter dated 24/1/25 to the learned additional government advocate inadvertently that the OGLS mistakes number 29 of 2003 has been disposed of. Thereafter, when the error
Misread the same.
And you have given the undertaking to dispose it of within 45 days.
petitioner cooperates in it.
That is
Yes,
relevant.
why you will not cooperate? What is it? He wants for that purpose he has come here. So, all right, we are disposing of the
With the undertaking that you will cooperate.
Yes, ma'am.
the as per the order dated 4/2/2025, the additional Tahsildar Sadar Sambalpur has filed affidavit on behalf of opposite party number 3, wherein he has given undertaking
In a sheet.
and yourself,
Yes.
wherein he has given undertaking. No, here he has stated that the letter dated 3/2/2025 of the collector Sambalpur reflects the correct position as regards the OGLS miscase number 29 of 2003, and the same is pending, and he has also given an undertaking to dispose of the said OGLS miscase within a period of 45 days, subject to cooperation of the petitioner. The land counsel for the petitioner submits that the petitioner will cooperate with the opposite party number 3 for early disposal of the aforesaid so-and-so OGLS miscase. In view of the affidavit filed and the submission made by the land counsel for the respective parties, we direct the opposite party number 3 to dispose of OGLS so-and-so within a period of 45 days from the date of production of the certified copy of the order. Accordingly, the writ petition is disposed of.
Item 5.
I need taken up next week. I need to file that RR scheme, hearing decision. You have taken time for what purpose? I need to file that scheme from the last occasion.
We give you extra time on that day, but you said you'll
To produce the
Next week, I'll do it.
All right. The land counsel for the petitioner seeks some more time to produce the scheme, which was equivalent at the time when Annexure 2 dated 22/10/1999 was prepared. List this matter. March of
Item 6.
I don't think you'll also call this letter next week because I have lost my glass somewhere.
Lost my
Glass.
বার বাজিয়ে দিয়েছেন না ঘরে
reading class যদি আমি কিনে যাচ্ছি ঘরে
The land counsel for the petitioner seeks for an adjournment. Kebera kya kundu?
personal inconvenience.
Next week.
For personal inconvenience. Next week. All right. We commencing from 17th February 2025. Yes.
Item 7.
Item 7, I may be pardoned to appear through VC, my lords. My lords, my learned senior Mr. Panigray is not well today, my lords. He is suffering from fever. For that reason, my lords, I am seeking for an adjournment.
Mr. Sharma. Shubham Sharma, the power will be argued by Mr. Panigre.
Mr. Shubham Sharma, when counsel appearing to particular mode submits that Mr. B. Panigrai is supposed to argue this matter is not well, and the matter may be taken up next week. You want?
Any day, your lordship. Any day, your lordship may fix a date.
All right. Next week, 17 to 2025. All right. Along with the WPC numbers.
Or do you want more time?
No, my lord. 17 is fine, my lord.
Yes.
Item 8.
My clear. And petition challenges the order dated 7 to 2024 passed by the Learned Administrative Central Administrative Tribunal, Cuttack, my lord, Annex of 13, page 50. The my lord, operating party item 61. The original application was dismissed on the ground of delay and lapses, and similar matter has already been enlisted before lordship, and notices has been issued.
Operative part रे लिखा है जी, this case is similar to ON number 739 of 23. So ON number 739 of 23 against रे अपन आश्चर्य read रे सेटा notice
सेटा है जी तापर similar matter रे my lord also reflecting all these things, my lord also not.
ଯାହା ଅଛି ସେୟା ଲେଖିଦେବେ ଆଉ ଏଇ ଯୋଉ ଲାଷ୍ଟ କି ଯୋଉ ଅଛି ତା ସହିତ ଏ ନମ୍ବରଟା ବି ଆଡ୍ କରିଦେବେ 30,824 ଯାହାର ଅର୍ଡର
Last sub-paragraph Learning Council for the State is of Union of India, my lord.
Union of India तो अच्छी
Union of India repetition along with all annexes we serve on the Learning Council for the State.
वो अच्छा था ओके এটা कुछ Union of India तो
ତାଙ୍କ ସେଇ କେସ୍ ରେ ଭୁଲ ହେଇଯାଇଛି
ନାଇଁ ଏଇ ଯୋଉ earlier ତିନିଟା କେସ୍ ମୁଁ କପି ୟୁନିୟନ ଅଫ ଇଣ୍ଡିଆ ଦେଇ ଦେଇଛି
କରିଛନ୍ତି ତାକୁ ଗୋଟେ ମେମୋ ଦେଇଦେବେ ଆଥର ଯେ ସେ କରିଛି ସୋ ଦ୍ୟାଟ୍ ୱିଲ୍ କରେକ୍ଟ ଦ ନେକ୍ସଟ ଡେ
ନାଇଁ ଓକେ
Item 9.
Item 9, my lords have directed the state to take instruction why the decretal amount has not been paid and is there any legal impediment in payment of the decretal amount. The instruction has not come, although you have immediately issued the letters. Lordship may give us one last opportunity.
Okay, the Land Council for the state, as per the order dated, may submit that as per the order dated 24/1/2025, instruction has already been sought for regarding as to why there is delay in sanction of the decretal dues and whether there is any legal impediment for such sanction or not. But the instruction is still awaited and the matter may be taken off.
1 week after money, so
a week after for them. Hard March roughly.
Next was a similar 10 was 7
March 2025. Next is same. All right. 3rd March 2025. Okay.
Item 11.
Item 11 permitted to withdraw.
I'll memo. Who is present for the Union of India? Okay, Mr. Padhi. Mr. Padhi.
Your name, please.
DS San.
DS San, you have got power. The item number 11. You are there. All right. Memo of withdrawal is filed. So please give. And for presence लिख दो.
कौन पे फाइल इतना भी लिख दो.
Eta prayer लिख दो. He has filed this application. Prayer this files in memo. Dispose of first withdraw. Memo is taken on that. Yes.
Item 12.
Contempt petition, my lord. That is the second contempt. And first contempt, my lord, after first contempt, that was challenged before the appeal court. And the appeal court also dismissed the SLP. And the direction of this honorable court is clearly a running page.
You approved this court earlier in one contempt petition.
One contempt petition.
That is contempt application number 2551 of 23.
My lord.
Annexure 1.
Annexure 1.
What order was passed? Let the opposite also, if not already compared, within a period of 3 months.
3 months. Thereafter, they were challenged before the appeal court.
Challenge what? The contempt order, the original order?
No, original order.
Where is that order?
Contempt order is a
No. What
they challenged the division bench order before the appeal court.
Supreme Court अपन कहले जे dismiss कले बेली Supreme Court करो judgment टा काहे? तो एटा जोटा ଦେଇଛନ୍ତି ଆପଣ ଆଚ୍ଛା 5/12/2024 ହେଇଛି
my lord.
Delay upon after hearing the counsel also on behalf of we see no reason for all right.
Thereafter, the direction of the honorable court running page 32, 33, para 21. This is the direction. The disengaged period salary has been granted by the division bench of the service. The disengagement period salary has been assessed by the division bench of the service. A clear direction number, para 21, page 33. They have to comply. Para 21.
No, it's all right.
Permitted to place.
No. Let him. Yes, you have challenged the order and it was confirmed by the Honorable Supreme Court. So who is that man?
Well, I'll slot you able to next week, Malak.
No, who is to carry out your order? Why have you engaged so many persons as opposite party? Who is to carry out the order? ଆପଣ 4 ଜଣ କଣ ପକ୍ଷ କରୁଛନ୍ତି?
Because they are the authority, direction is all opposite parties. For that reason,
instruction.
All right. Yes.
This contempt petition has been filed by the petitioner Madan Chandra Nayak. For deliberate violation of the order dated 10/5/2023 in contempt petition number 2551 of 2023 and order dated 10/5/2022 in WPC number 6277 of 2011. The Land Counsel for the petitioner submitted that the opposite party approved the Honorable Supreme Court against the order dated 19/4/2022 passed in WPC number so and so in SLP number so and so and the said SLP was dismissed on 5/12/2024. The copy of the order dated 5/12/2024 is filed and taken on record. Stop. At this stage, the Land Counsel for the state seeks some time to obtain instruction regarding compliance of the order of this court dated so and so you can 5/19/22 passed in so on. Put of this matter.
1 week after.
1 week after putting 3rd March 2025.
Item 14.
Another similar cases are pending contribution maybe tag.
No, you filed a memo will tag facility
judgment.
যেটা যদি আসি নথিব তাহলে ଆପଣ ଦେଇ ଦିଅନ୍ତୁ ମେମୋ ଦେଇ ଦିଅନ୍ତୁ ସେଟା ପଳେଇ ଆସିବ ହେଲା Yeah.
Item 13.
Mr. Sudhir Kumar Malik.
Yes, sir. Cover and matter, I've solved a couple of the previous one, only disposal of operators. Annexure number 3 and yes, sir. Please send the area. Area which is settle the land. Only have the Moja and council or change. Yes, sir, change only.
କିଛି ଚେଞ୍ଜ ଚାଞ୍ଜ ହବ ତା ଦେହରେ ଅର୍ଡରରେ
ଚେଞ୍ଜ ହବ
ଆପଣ ଆପଣ ଗୋଟେ ଚେଞ୍ଜ କରିକି ଦେଇ ଦଉନାହାନ୍ତି ଦେଇଛନ୍ତି ଦେଖିଲେ
ଦିଟା ଆପଣଙ୍କର ଅଛି 6ଟା ନା କେତେଟା 5ଟା
ଏ WPC ନମ୍ବର ଟା ଚେଞ୍ଜ ହବ ସବୁଥିରେ
ପାର୍ଟିର ନାଁ ଚେଞ୍ଜ ହବ
ପାର୍ଟି ନାଁ ଚେଞ୍ଜ ହବ
ଏରିଆ ଚେଞ୍ଜ ହବ ଖାତା
ନାଁ ଚେଞ୍ଜ ହବ
ମୌଜା ଚେଞ୍ଜ ହବ ସେଟା ଦେଖିବା
ଏଇ ଯୋଉ ଖାତା ନମ୍ବର ଲେଖିଛନ୍ତି 245 ଏଟା ସବୁଥିରେ ରହିବ ତ 245
ନା ଆଉ ପେଣ୍ଡିଂ ସେନ୍ସ 8/1/2020 ନା ଅନ୍ୟ ଡେଟ୍ ସବୁ ଗୁଡା କରିବାକୁ
ନା ଏମିତି ଆପଣ ଯଦି ଚାରିଟା ଯାକ କେସ ରେ ଅଲଗା ଅଲଗା କରିବାକୁ ପଡିବ ଆପଣ କରିଦଉନାହାନ୍ତି ସେଗୁଡା ଗୋଲ ବୁଲେଇକିନି ପ୍ଲଟ ନମ୍ବର ଆପଣ ଖାତା ନମ୍ବର ଏଗୁଡା ଯଦି ଅଲଗା ପୁଣି ନହେଲେ ପୁଣି ଆମକୁ ଦେଖିବାକୁ ପଡିବ ଆପଣ ଯଦି କରିଦେବେ ତ ଅଲଗା କଥା
ସେଇ ଗୋଟେ କାଗଜରେ ଅଲଗା ଡିଟେଲ ଗୁଡା ସବୁ ଦେଇଦେବେ
ଗୋଟେ କାଗଜରେ ଟିପିକି ଦିଅନ୍ତୁ କୋଉ ମାନେ ଏଇ ଅର୍ଡରରେ କୋଉ ଲାଇନ ରେ କଣ ପଶିବ ସେମିତି କରିଦେଇ ଦିଅନ୍ତୁ
ଆମ ରୁମରେ ପୁଣି ଶୁଣାଣି କରିବୁ ଆମେ ଆଉ ଥରେ ପରା take a direct decision afresh. Afresh. Afresh ମାନେ ଥରେ ମନା କରିଥିଲେ ଆଉ ଥରେ afresh without setting a fresh ନା କଣ ସେ କରୁଛନ୍ତି
submitted that the representation on this issue is pending for this one so no
afresh ଟା ରହିବ
from this one and it also may belong
in this case the direction was to collect to the collector to take a
decision
ତାହେଲେ afresh ଟା ରହିବନି କାରଣ ସେଟା ନେଇନାହାନ୍ତି ଓ ସେ ଆଉ ଥରେ ଫାଇଲ କରିବେ
ଚାଲୁଛି ଆଉ ମାନେ କୁଆଡେ କଣ ସେ ଯାଇଥିବ ରିପ୍ରେଜେଣ୍ଟେସନ 20 ମସିହା ରିପ୍ରେଜେଣ୍ଟେସନ ଗୋଟେ ପୁରୁଣା ହେଇଗଲା ଏଠି ଆପଣଙ୍କ ରିପ୍ରେଜେଣ୍ଟେସନ କେବେ
ଶୁଣନ୍ତୁ ଏଠି ନୂଆ ଦବ ବୋଲି ଗୋଟେ ଲେଖା
ଏଇଟା ପାର୍ଟିକୁଲାର
ଟିକେ ଚେଞ୍ଜ କରିଦବା ଗୋଟେ ଚେଞ୍ଜ କରିଦେଲେ ହେଇଯିବ ଖାଲି ଆର ଡିଟେଲ ଗୁଡା ଟିକେ ଚେଞ୍ଜ କରିଦବା ଆପଣ ଦେଇଛନ୍ତି ରିପ୍ରେଜେଣ୍ଟେସନ ବୋଲି କଣ ଅଛି ଡକ୍ୟୁମେଣ୍ଟ ଅଛି
କୋଉଟା
20/12
ନା ଆନେକ୍ସଚର କେତେ ଆପଣଙ୍କ ରିପ୍ରେଜେଣ୍ଟେସନ ଟା
ଆନେକ୍ସଚର 2 20/1 ପୁରା 20/12 କଣ ଲକ୍ଷ୍ମୀ ପ୍ରିୟାରେ 20/1 ଗୋଟେ ଦେଇଛନ୍ତି 20/12 ଆପ୍ଲିକେସନ ଫର୍ମ ନମ୍ବର 1 ଆପ୍ଲିକେସନ ନମ୍ବର ଆପ୍ଲିକେସନ ଡାଟା 20/12
ନା ଏଗୁଡା ସବୁଗୁଡା ଚେଞ୍ଜ କରିବ ଥିବ ଆପଣ ଡେଟ୍ ଗୁଡା ଚେଞ୍ଜ କରିବ ଏତେ ଜିନିଷ ଆପଣ ଗୋଟେ ଲେଖିକି ଦିଅନ୍ତୁ କଣ କଣ ଚେଞ୍ଜ ହବ
ଆପଣ 20/1 ରେ ଗୋଟେ ଦେଇଛନ୍ତି ଆଉ 12 କୋଉଠୁ ପାଇଲେ ଆପଣ ତାର ରିପ୍ରେଜେଣ୍ଟେସନ ଟା ନିଜେ 20 ଆଉ ସେ ତିଆରି କରିଥିବେ ଯୋଉ ଡେଟ୍ ଟା ପକେଇ ଦେଇଥିବେ ହଁ ଆଚ୍ଛା ଆଉ ଇଏଟା କାଇଁ ପୋଷ୍ଟାଲ ରିସିପ୍ଟ ଟା କାଇଁ ପୋଷ୍ଟାଲ ରିସିପ୍ଟ ପୋଷ୍ଟ କଲେ ଗୋଟେ ପୋଷ୍ଟ ଅଫିସ ରୁ ଗୋଟେ ଚିଠା ମିଳେନି ଆଜ୍ଞା ସେଟା ଅଛି 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 ସେଟା ଆମକୁ ଦେଲେନି ହଉ
ଅଛି ତ ତାର କେବେ ଦେଇଥିଲେ ସେଟା ସେଇ ଡେଟ୍ ଟା ସେଇ ଡେଟ୍ ରେ ଦେଇଛନ୍ତି ତ ଯୋଉ ଡେଟ୍ ଲେଖିଛନ୍ତି ଆପଣ
ନାଇଁ ଏଇଟା ପୁରା ସେ ଆଉ ଗୋଟେ ଡେଟ୍ ସେଇଠୁ କହିଲେଣି ଏଇଠି ଅଛି 20/1 ପାଇଲେ ହଇରାଣ ହୁଏ ସେ ଗୋଟେ କରିକି ଦେଇ ଦିଅନ୍ତୁ
ଆପଣ ଦିଅନ୍ତୁ ସେ ଯୋଉଟା କରେକ୍ସନ ହବ ଏଇ ଅର୍ଡର ଟା ଯୋଉଟା ଡିସ୍ପୋଜର ରେ ଆପଣ କେତେ ଗୁଡା କରେକ୍ସନ ହବ ତ ରିପିଟିସନ ନମ୍ବର ପାର୍ଟି ନା ଏସବୁ ତା ଛଡା ପ୍ଲଟ ନମ୍ବର ଖାତା ନମ୍ବର ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ଆପଣ କୋଉଥିରେ କଣ ରହିବ ସେଟା ଦେଖିକି ଦିଅ
ଆପଣ ନାଁଟା କଣ କହିଲେ ଗୀତାରାଣୀ ମଲ୍ଲିକ ତ ଆପଣ ଦେଇପାରିବେ ନା ମିଷ୍ଟର ମଲ୍ଲିକ ଆସିବେ ଦେବେ ତାହେଲେ ସବୁ ଡିଟେଲ୍ସ ଗୁଡା ଦବାକୁ ପଡିବ ଆଉ ରେଜିଷ୍ଟର ଦେଇନାହାନ୍ତି ସେଟା ବି ପିଲାଙ୍କୁ ସୁବିଧା ହବ ଆଉ ଦବା ପାଇଁ ପଡନ୍ତା। ଆଉ ଗୋଟେ ନୂଆ ରିପ୍ରେଜେଣ୍ଟେସନ ଦେବେ, ନୂଆ ହେଲେ ପୁଣି ମୂଳରୁ start ହବ। ଅଛି ହଁ ସେଟା ଟିକେ ବଦଲେଇବା ଆଉ।
ଆପଣ ଏଇ ଯୋଉ ରିପ୍ରେଜେଣ୍ଟେସନ ଯୋଉ ଦେଇଛନ୍ତି ପ୍ରତ୍ୟେକ କେସ୍ ରେ
ଆଜ୍ଞା
କେବେ ପୋଷ୍ଟାଲ ରେ ପଠେଇଛନ୍ତି
ଆଜ୍ଞା
ତାର ଡେଟ୍ ଟା ଆପଣ ଇଣ୍ଡିକେଟ କରିଦିଅନ୍ତୁ। ପ୍ରତ୍ୟେକ କେସ୍ ର ପାଇଁ ଗୋଟେ ଗୋଟେ ସ୍ଲିପ୍ ଦେଇଦିଅନ୍ତୁ।
ଆଜ୍ଞା
ତାଙ୍କୁ ସେ ଯୋଉ ଆମର ଯୋଉ ଅର୍ଜେଣ୍ଟ ସ୍ଲିପ୍ ନା ତା ଯୋଉ ଦେଇଦିଅନ୍ତୁ 1 2 3 4 5 ପାଞ୍ଚଟା ସ୍ଲିପ୍ ରେ ସେ ରିପିଟିସନ ନମ୍ବର ପକେଇ ସେଗୁଡା ଚେଞ୍ଜ କରିକି ଦେବେ। ଆଉ ତା ଦେହରେ ପୋଷ୍ଟାଲ ରିସିପ୍ଟ ଡେଟ୍ ଗୁଡା ଦେବେ।
5ଟା କାଗଜ ନେବେ, କେସ୍ ନମ୍ବରଟା ଉପରେ ପକେଇବେ, ପାର୍ଟିର ନାଁଟା ଲେଖିବେ, ଆଉ କୋଉ ଜାଗା ପାଇଁ ମାଗିଛନ୍ତି ସେଇଟା ଗୋଟେ ଲେଖିବେ, କୋଉ ଦିନ ପଠେଇଲେ ସେଇ ଡେଟଟା ଲେଖିବେ, ଆଉ ରେଜିଷ୍ଟର୍ଡ ପୋଷ୍ଟରେ ଯୋଉ ପଠେଇଛନ୍ତି ସେଇ ଦିନର ରିସିପ୍ଟର ଡେଟଟା ଲେଖି ସେଟା ଲେଖିଦେବେ।
କାହା ପାଖକୁ ପଠେଇଛନ୍ତି ସେଟା ବି ଲେଖିବେ। ଅପୋଜିଟ୍ ପାର୍ଟନର 2 କି 3 କି କିଏ ଯିଏ ବି ହଉ ହେଲା।
ଆଉ ପରଠୁ ଯେତେବେଳେ ଫାଇଲ କରିବେ ସେ ରେଜିଷ୍ଟ୍ରେସନ ର ଗୋଟେ କପିଟେ ଦେଇଦେବେ, ସୁବିଧା ହବ। ଏବେ ଦେବି ଆଜି ଦିନରେ ଦିଅନ୍ତୁ। ଆଜ୍ଞା କଣ କହିଲେ? ଏଇ ଯେ ସେଟା ଆମର ଧରା ପଡିନଥିଲା ଏଠି। ହଁ
Item 15.
May I please allow? The petitioner eligible Orsi to early disposal of the OGLS case number 49 of 2015 pending before the open number to Tahsildar Contempt.
2015
In the meantime, the OGLS case has been dismissed. The petitioner preferred the appeal under Annexure 1. In appeal, the appellate authority directed to fresh adjudication of the OGLS case. The appeal order passed in 12/7/2024. Since then, it is
Mr.
pending.
Counsel, this matter has become infructuous because this OGLS case has already been disposed of.
There are to file appeal or can say Annexure 1.
ଆପଣଙ୍କ ପ୍ରେୟାର ଟାକୁ ଦେଖୁନାହାନ୍ତି।
ପ୍ରେୟାର ଟା କପି ପେଷ୍ଟ କରିଦେଇଛନ୍ତି ତ ଭୁଲ ହେଇଗଲା।
ଆପଣଙ୍କ ପ୍ରେୟାର ହଉଛି OGLS କେସ୍ ନମ୍ବର ହଉଛି 49 of 2015। ଆପଣ ବର୍ତ୍ତମାନ ସବମିଶନ କଲେ ଯେ ଏଇ କେସ୍ ଅଲରେଡି ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଗଲାଣି, ତା ଏଗେନଷ୍ଟ ଅପିଲ କରିକିନି ପୁଣି ଦେଇକିନି ମ୍ୟାଟର ଆସିଛି। ଆଉ ଯୋଉ OGLS କେସ୍ ରେଜିଷ୍ଟର୍ଡ ହେଇଛି ଦ୍ୟାଟ୍ସ ଏ ଡିଫରେଣ୍ଟ ନମ୍ବର।
That is not different now. Same case remanded. Same case remanded or she can say Annexure 1.
The same number has been
Same
after
number
remand, same number has
Same number.
document
Same
NC page 30
No, appeal has been disposed of, so
and remanded back to the
okay.
page 30 order dated 27/24 is clear.
appeal ଟା ସରି ରିମାଣ୍ଡ ହେଇଛି କେସ୍ ଟା, ରିମାଣ୍ଡ ପଡିଛି ଯେ ଏତେ ଜଲ୍ଦି ସେ ଡିସାଇଡ କରିଦେବେ ବିନା ନୋଟିସ ତ ଅଛି। ନୋଟିସ ହବ କଣ
It was posted for 7/11/24 for finding of
order in operative part also ଲେଖା ହେଇଛି the case record is remanded to the lower court for a case adjudication. The lower court is directed to implead all legal heirs of late Mansaram Mansaram Agrawal as parties to the case, issue them individual notices, and after giving them opportunity of hearing fast final order by adhering to the provisions under section so and so. So ଆପଣ ସେ ଯୋଉ ନୋଟିସ ଭରିଆ ଯିବା କଥା ଏଗୁଡା ସବୁ ଗଲାଣି ଭରି
And deposit court notice issue with order sheet ଅନୁସାରେ last date ଥିଲା।
ତ ଆମେ ବର୍ତ୍ତମାନ କିଛି ନ ଦେଖିନି ଗୋଟେ ଅର୍ଡର ଯଦି କରିଦବୁ ଆପଣ ଗୋଟେ ଟାଇମ ଷ୍ଟିପୁଲେଟେଡ ତା ଭିତରେ ନୋଟିସ ସର୍ଭ ହେଇନଥିବ ତାହେଲେ ସେ କେମିତି ଡିସ୍ପୋଜ ଅଫ୍ କରିବେ?
Lordship can see page 35 for a moment.
Yes.
ଆଗରୁ ବି କେସ୍ ଥିବ, ଆପଣ ଏଠି ହାଇକୋର୍ଟ ଆସିଲେ ଆପଣଙ୍କର
Yes,
ଫାଷ୍ଟ
sir.
ନେଇ
Page 35 the last annexure.
ପୁରୁଣା କେସ୍
35 କଣ ହେଲା?
Order sheet 2/10/24.
ଏଟା କଣ OGLS କେସ୍ ନମ୍ବର 49 of 2000? ଆଚ୍ଛା ହଁ କଣ ହେଲା?
15.
ହଁ
The order sheet 2/10/2024 Lordship. The case record is put up today. Both parties are present on call. Advocate for the petitioner is Sankalal Orba file a time petition.
ତାମାନେ ଆପଣ କହୁଛନ୍ତି ସବୁ ପକ୍ଷ ତକ appear କରିଗଲେଣି ଏଇଆ କହୁଛନ୍ତି?
ଆଜ୍ଞା।
Shankarlal Agarwal is the only opposite party.
Sankalal Orba for the petition Sankalal Orba file a time petition.
From these parties are appear. Tapore time. This writ petition has been filed by petitioner Sivanarayan Agrawal with a prayer for direction to the opposite party number Tahsildar Kantavanji to dispose of OGLS case number 49 of 2015 under annexure C. The land counsel for the petitioner submits that against the order dated
also do the other store
10 to 2016 of Tahsildar Kantavanji in Nazur, OGLS case number 49 of 2015, Nisapil case number 1 of 2021 was filed and by that dated 12/7/2024, the sub-collector and revenue officer Titlagar has been pleased to remand the case to the opposite party number 2 for fresh adjudication with a direction to the opposite party number 2 to implement all the legal heirs of late Mansaram Agrawal as parties to the case and to issue them individual notices, and after giving them an opportunity of hearing to pass final order adhering to the provisions of the GLS Act 1962. The Land Council for the petitioner has annexed the order sheet of OGLS case number 49 of 2015 and submits that after passing of the order in Miss Appeal number 1 of 2021 dated 12/7/2024, steps have already been taken by the opposite party number 2 and all the parties have already entered appearance, and therefore there would be no hindrance in directing the early disposal of the said case. However, we are of the view that if an application for expeditious hearing of the aforesaid OGLS case number so and so is filed before the opposite party number 2, Tahsildar Kantavanji, and if all the parties have already entered appearance and the pleadings are complete, necessary order shall be passed by the opposite party number 2 in disposing of the said application and taking further steps for expeditious disposal of the said case. Accordingly, the writ petition is disposed of here.
No
time may be fixed.
Disposal, we have not expressed any
Yes.
opinion on the merits. Yes.
time limit
टाइम लिमिट हेला पुଣି first column second
ସିଏ ଦେଖିବେ କୋଉ ପକ୍ଷ ଇଏ କଲେଣି ନାହିଁ, ଯଦି ସବୁ ଠିକ ଠାକ ଥିବ ତାପରେ ଇଏ କରିବେ. Yes. Next.
item number 16 is similar, madam.
Same, similar.
Similar can be fresh, madam. OGLS case number 2/20.
সেটাতে খালি OGLS case number change হবে.
ମାନେ ଏକ୍ସାକ୍ଟଲି ନୋଟିସ ନଥିଲା ସେଇ ଗ୍ରାଉଣ୍ଡ ରେ ହିଁ ଦଳକୁ ରିମାଣ୍ଡ ହେଇଛି।
ସେ ସୋଜିଏଲ୍ସ ଆପ୍ଲିକେସନ କରିଥିଲେ ଇନକ୍ୱାରି ହେଇଯାଇଥିଲା
Not been demanded. It has not been demanded.
it is not remanded fresh
We'll come back and see.
Item number 16,
16 Miller, the OGLS case number 2/24. This case, the inquiry has been conducted by the concerned RI to expedite disposal of this OGLS case.
So no case filed before you is pending. ଆପଣଙ୍କ ପୂର୍ବରୁ କିଛି କେସ୍ ପେଣ୍ଡିଂ ନାହିଁ filed before that.
Fresh one will.
ଆପଣ ବୁଝୁନାହାନ୍ତି. Why should your case be taken out of turn and disposed of? That is what I am asking.
Yes, ma'am.
Remand matter. If you want to pass this type of order, then it would open the floodgate for everybody would come here, early disposal. Your case is of the year 2024, and it seems that it was filed maybe in January or February. And it is not the case that all the cases up to 2023 has been hearing has been completed and orders have been passed. So when old cases are there, why your particular case will be given preference? Because you are able to approach this court and take an order. Are you following?
Yes, ma'am.
So once we pass such type of order, then everybody would rush to this court to take that would create an additional pressure on this authority who is supposed to dispose of.
You can withdraw and file in case there is delay in disposal.
Well, Lordship, may direct file a representation before the
Representation, writ petition has been filed by the petitioner so and so for early disposal of OGLS 2 of 2024 by the opposite party as Tahsildar Contempt, that is opposite party number 3 million. Since after going through the order sheet filed in this case, we do not find that there is any such delay in disposal of the aforesaid case. Therefore, the
dispose of this, granting liberty to whom to apply the court in case there is.
Therefore, for disposing of this writ petition, liberty is granted to the petitioner to approach the so and so in case there is delay in disposal of so and so.
Item 17.
Disposal person in case there is disposal of the SAD.
For direction to the authority opposite number 3, representation can annex 4, page 60.
Representation the number.
For disposal of representation. Direction.
No. Representation ଉଦ୍ଦେଶ୍ୟଟା କଣ ମାନେ ଚେନାଲରେ ଅଧିକୃତ ଜମିର ଅଧିକ କ୍ଷତି
higher compensation for benchmark balance.
Higher compensation 28A ନା ସେମିତି ଖାଲି
20
64
20
64 of say RFCT.
ସେଟା କେତେ ଦିନ ଭିତରେ ଦବା କଥା
ସେଟା
ଜୁନାଲ
ଦେଖି ଦେଲେ
64 ର ଆପଣ
କେତେ ଦିନ ଭିତରେ ଦବା କଥା petition
proceeding
ଏଠି ସବୁ delay ହେଇଯିବ 54 ଟା
64 जो procedure ଅଛି ତାକୁ କଣ ଏମିତି ଇଏ କଲା ହବ ନା ତାକୁ reference କରିବାକୁ ହେଲେ any person interested who has not accepted the award may by written application to the collector ଏଟା କାହାକୁ ଦେଇଛନ୍ତି collector and application of the collector. Matter may be referred by the collector for determination of the authority, as the case may be, where his objection so and so.
That means you file an application for reference. Disposal of representation.
উপরোক্ত বিষয় ନେଇ ଶୁଣାଣି ନୂତନ ଜମି ଅଧିଗ୍ରହଣ ଅବଲମ୍ବନ କରି ଜମି ଅଧିଗ୍ରହଣ ଆଇନ ଅନୁଯାୟୀ ଆମକୁ ନ୍ୟାୟୋଚିତ କ୍ଷତିପୂରଣ ଶୁଣାଣି ଆମେ ଜମି ହରେଇଥିବା ଶୁଣାଣି
ଆମେ କଣ ଅଥରିଟି ଦବା ନାହିଁ?
authority is the district judge. Authority is that civil court, the principal civil court.
ଆମକୁ କହିଦେଲେ କରିଲେ ନା।
Authority has been under petition transfer.
এটা অফিসে পড়ে এসে collector কথা ছিল নাহলে succeed from receiving the notice. After within our 1 person can entertain. But authority ବୁଝିବେ ନା ଆମେ High Court ପଳେଇଲେ କେମିତି ହବ?
Authority by representation ଦେଇଛି, he has to refer it to the
authority ଟା କାଇଁ?
in this case wish to dispose of that decide that matter. The
Opposite number 3.
Okay.
John officer from John officer.
No. If you are dissatisfied with the determination of the award and or the amount of compensation, then the reference is to be made by the collector to the authority for determination. So that authority is
DLBC. DLBC.
Yes, Mr. Behra.
Land acquisition rehabilitation so 52. 52 টা পর বলছেন যে the authority shall consist of notified by the appropriate government. Whether it is the district judge or the
who is the authority who has, have you said who has been notified as the authority? Because if he is not disposing of, you have to approach the authority as per section 64.
Collector. Elect collector.
Collector ଯଦି କରୁନଥିବେ ତାହେଲେ ଆପଣ authority ପାଖକୁ ଯିବେ।
collector କୁ ଦେବେ, collector reference କରିବେ authority କୁ। ଯଦି collector ନ କଲେ particular time limit ଭିତରେ, then you can approach the authority directly. है ना? ସେଥିପାଇଁ କୁହାଯାଇଛି provided further that where the collector fails to make any such reference within the period so specified, the applicant may apply to the authority as the case may be, requesting it to direct the collector to make the reference. जोड़ा से करनथिबे से direction करिवे. Authority has been defined under 3F of this 2013 Act. Authority means the land acquisition, rehabilitation and resettlement authority established under section 52. 52 कहूची composition of authority. The authority shall consist of one person only, hereinafter referred to as presiding officer, to be appointed by notification by the appropriate government. Appropriate government may authorize presiding officer of one of the authority to discharge. So, a case presiding officer key, whether it is the
special tribunals are established for that. Special tribunals are established for that.
This type of cases are adjudicated by the
reference.
Oh, that is the district. Original is the district judge. The principal civil judge is the authority. You see the qualification for appointment of the presiding officer, section 53. A person shall not be qualified for appointment of the presiding officer unless he is or has been a district judge. So the principal civil court is to adjudicate the matter. He is the district judge, and this reference is to be made by the collector to the district judge. So if the no reference is made, then you can approach directly to the district judge, so that district judge will direct the collector to make the reference. It appears from that.
Direction may be depend us to consider on that.
representation procedure thibo ame kemti representation
You first of all you read out these provisions. Hala 64 पढ़ंतु, definition पढ़ंतु authority रो 52 53 पढ़ंतु हाला तेणु ए केस रे authority किए hala the authority, it appears that authority is the principal civil district judge. From the original side ro he will be the competent authority. You also, Mr. Behra, you go through it. We'll take up this matter tomorrow.
yes disposal of representation we should follow the proper procedure application daba pen thibo ame representation dispose of karibu kemti hobo
Put up this matter tomorrow as prayed for by Mr. Subrot Ponda. Yes. To enable him to go through the respective provisions of the 2039.
Item 18.
Similar cases finally passed in order matter. I have already made
term of compensation under what provision representation dele je act re kichi nai koটা रे karibo
they order say taku eight they are not follow
the what
benchmark valuation taku is very much higher than the compensation amount.
तो सेटा representation कले से एटा ही जो
मतलब
जो compensation गोटे सुनी की करथिबे thereafter I will accept or you
benchmark valuation I have already annexed my
बुझना दे जो compensation act अनुसार there is a procedure अनुसार they fix some valuation thereafter खाली representation देले change हो जो proper procedure गोटे follow करिवेनी सेटा कोटा को section
You see, re-estimate compensation amount means the act says that suppose you are not satisfied or the quantum of the quantum taku madhya apana raise kari paribe which is to be adjudicated by the reference ei paribo ei ground re 64 re.
Have you given an application on the 64 or just representation?
That's no need for application, man.
I guess
that's no need for any application.
There is no need for application.
Yes, my lord, need for application, man.
So where is that application?
Then not only retention is my man.
So that is to be treated as an application.
There is under second section of the need to make an application before the authority.
Authority,
not my authority, but the
collector.
Yes, man.
If any person has not accepted the award, he has to submit an application to the collector. Hala? I'll say the measurement of land ro gondogol heichi, amount of compensation re apan satisfied nuhanti ba jo mane entitlement tadire madhya kichi apankor objection achi kahar, then in such case the application has to be made to the collector. right? And prayer is to be made that it is to be referred for determination by the authority. Authority means in this case is the district judge. So district judge is to adjudicate that in case the reference is not made, then the party can approach the authority directly, so that the authority will direct the collector to make the reference. But the period stipulation is there that within what period you are to make the.
तो आपण जो आनेक्स 6 ଦେଇଛନ୍ତି କେବେ ଦେଲେ?
So 6 ମାଇଲା
ହାତରେ ଦେଲେ ନା ପୋଷ୍ଟ ପଠେଇଲେ ନା କେମିତି କଣ କଲେ? ଅଛି
by hand ମାନେ କାରଣ ପୋଷ୍ଟାଲ ସ୍ଲିପ କିଛି ନାହିଁ ସେ ଦେଇଛି କୋଡି
ହ୍ୟାଣ୍ଡ ମାନେ ହାତରେ ସେ ଅଥରିଟିଙ୍କୁ ହାତରେ ଧରେଇ ଦେଇକି ଆସିଲେ
ମାନେ ଅଫିସରେ
ଅଫିସରେ
କିନ୍ତୁ there is not any
ସେ ଏନିଟା
acknowledgement regarding the receipt of this application.
କହିବେ acknowledgement ଆପଣ ଦେବେ
Yes ma'am.
because section 64 says ଯେ notice ପାଇବାର 6 week ଭିତରେ you have to give and in case there is delay there is provision for ମାନେ ବର୍ଷେ also they can condone the delay. So the procedure has to be followed.
You may make a direction to make a fresh application.
ପୁଣି flash ଆସିଲେ delay ହେଇଯିବ 6 weeks ଭିତରେ ଦବା କଥା ନା ଯଦି fresh ଦେବେ delay ହେଇଯିବ
ଆପଣଙ୍କର prayer କଣ କରାଇଛି ଆପଣଙ୍କର ultimately
disposal representation ଥିବ କଣ କେମିତି ହବ in the nature of certiorari writ of certiorari ଆମେ ପଠେଇବୁ for disposal of representation still वो बढ़िया
direction ଦିଆଯାଇଛି କେବଳ consideration of the representation and excessive further to re-estimation.
ବୁଝିକି ଆସନ୍ତୁ କେବେ ଦେଲେ କଣ ହେଲା ସେଟା ଅଥରିଟି ପାଖେ ପହଞ୍ଚିଛି ତାଙ୍କ ରେଜିଷ୍ଟର ହେଇଛି କି ନାଇଁ କୁହନ୍ତୁ ହେଲା ତାହେଲେ ଦେଲେ ହବ
Can we adjourn this case in the meantime? I have taken instruction.
Though in this writ petition, prayer has been made by the petitioner Padman Kumar Dalai for a direction to the opposite party number 6 to take necessary action regarding consideration of the representation under Annexure 6 and to re-estimate the quantum of compensation as per government benchmark valuation and nearest vicinity area. The land council for the petitioner submitted that the
in view of section 64
in view of section 64 of so 2013 Act,
necessary instruction.
he has to obtain necessary instruction, and therefore the matter may be taken up next week. What is this matter?
सब जगह से
Yes. In all the cases, I will take.
Same order for the.
Here, Mr. Ojha.
No, my lord, I have to pick him.
Sorry.
Someone.
Mr. P.K. Madh.
Mr. Pritam.
P.K. Madh. So, it has to order for you next week.
Item 19.
May I please? Now, Lords, despite the order passed by the Lords Senior Civil Judge Bhubaneswar in a LA case, Lords, Lords, I have not been able to get the compensation amount. Lords, Lords, may kind of a glance to page 18, my Lords. Page 18, Lords, para 2. The land pertains to original Khata number 604 stood recorded on the name of Vasudev Jain, actually Vasudev Patram. The LAO acquired land by declaration number so dated 23/9/2009 appertaining to Khata number 604, plot number 505, 463, 503 and 506, area 44 decimal and others also. Now, thereafter, the next page, page 19. Lords, the land acquisition officer referred the matter to this court under section 13 of the LA Act for necessary apportionment of the compensation amount deposited by Allahabad Bank for the branch check number so and so dated 26/11/2011. Hence this reference. Lords, thereafter, Lordship may kindly take to the ordering portion, my lords.
Order means page number 25, internal page is 10.
Yes, lords.
So this was passed that who is entitled to what?
The order, my lords, the land acquisition reference is disposed of with following order. It is held that the claimant Rukmini Panda, the present petitioner, my lords, will be entitled to the compensation amount in respect of land Khata number 604, plot number 463, area 30 decimal, plot number 503, area 5 decimal, plot number 506, area 5 decimal. That is my claim, lords. 40 decimal only, lords.
So there is no dispute.
No, there is no dispute.
No dispute between the parties.
No. Lords,
And this order was passed on 18/4/2024.
my lords.
Yes.
Now, lords, thereafter, lords, I could not be able to get the money, for which I moved the lords civil judge senior division, but I was replied that since I have already passed the judgment, I became contempt of the show. So I cannot. Thereafter, my lords, I approached the lords register as well as the legal.
Register ହବନି ମୁଁ ସେ ଆଙ୍କର ଅଫିସର ଅଛନ୍ତି ଦେବେ ନା ରେଜିଷ୍ଟର କଣ ଦେବେ ପଇସା
Civil court ରେ pending ଅଛି, deposit ହେଇକି ଅଛି. 11 has already deposited since 2011.
କିଏ ରିଲିଜ କରିବେ
Amount of the deposit ହେଇଯାଇଥିବ ନା. So once the court held that this man is entitled to get the compensation amount for this land.
You get instruction.
ତା ପାଇଁ ଯାହା ଥିବ amount ତାଙ୍କୁ disbursement କରିବେ. Okay. ଲେଖିଦିଅନ୍ତୁ the land counsel for the petitioner referring to the order judgment and order dated 18/4/2024 passed by the senior civil judge Bhubaneswar in LMS case number so and so submits that to is the operative part of the order
common judgment.
In the common judgment. ଆପଣଙ୍କର ଆଜି କୋଉଟା?
Lords, same property, same check. Three cases.
ସବୁ ଅଛି ଗୋଟେ portion ର କହିଛନ୍ତି
28
ସବୁ କେସ୍ ନମ୍ବର ଗୁଡ଼ା ଲିଖ
28
in that case ଲେଖିବେ ନା. Stated that
amount is not being disbursed.
the petitioner is entitled to the compensation amount in respect of so and so, but till date petitioner has not received the compensation amount. Land counsel for the state takes some time to obtain instruction as to why the compensation amount has not yet been disbursed in spite of the order of the court, opposite order, opposite judgment of the client senior civil judge Bhubaneswar. Place this matter in the week on 24th February.
2 weeks.
2 weeks ଆପଣ ବୁଝିଦିଅନ୍ତୁ. Yes.
Item 20.
Compensation in lieu of land acquisition. In similar matter has been disposed of by this honorable court by the Annexure 6, page 20 to 25. Annexure 6, page 22 to 25. Same mauja, same tahsil melo, khata plot are different. Page 25, Annexure 6, last but one para in view of the above, we disposed of the real person with the direction to the opposite party, more particularly the Tahsildar from land acquisition officer OP number 4 to disburse the compensation amount as expeditiously as possible within a period of 2 months from today.
That was order number 9 in that writ petition. Today it has come up for the first time. So without instruction, how can we say it may be paid?
Same mauja, same tahsil matter.
No, getting obtain instruction.
Another matter is lordship lordship disposed of by WPC number 1097.
ଗୋଟେ ଦିଅନ୍ତୁ ଦେଖିଦିଅନ୍ତୁ।
Recent case.
Regarding that same thing,
Yes, yes. Same mauja, same tahsil.
representation ଆପଣଙ୍କର କାଇଁ?
Representation annexure 5.
ନା ଏଇଠି ଯୋଉ ଡେଟ୍ ଗୁଡା କାଇଁ? ଏଇଠି ତ ଗୋଟେ ଆପଣ 2019 ଗୋଟେ 23 ରେ ଦେଇଥିଲେ, ଏଇଠି କଣ?
ଏଠି annexure 5 series ରେ same village mail ଅଛି।
Maybe even some that model opposite to the opposite party essentially discussed within sub the instruction may be correct.
ନା ଫାର୍ଷ୍ଟ ହବା କଥା if କରିଦେଲେ ଠିକ ହବ ନାଇଁ?
Disburse the consumption. Two months. Instead of if particular, if had already been taken.
challenge করতে
If there's amount ରେ ଯାହା ସବୁ ଲେଖା ସବୁ ସମାନ
ମାନେ ଏକା
ଏକାନି ଖାତା ପ୍ଲଟ ଖାତା ପ୍ଲଟ ଡିଫରେଣ୍ଟ ସେମ ମୌଜା ସେମ ତହସିଲ
ଟିକେ ପଇସା ଦିଆ ହେଇଛି
ସେମ ମୌଜା ସେମ ତହସିଲ।
ଆଚ୍ଛା ନାଇଁ ନାଇଁ ଏ ଯୋଉ ଏକର 0.4 ପଏଣ୍ଟ ଏଟା ତ ହବନି
ଅନ୍ୟ ମୌଜା ସବୁ ଦିଆ ହେଇଛି।
ଆପଣ ଗୋଟେ ତଳେ ତା ଦେହରେ ଅଛି it is contained that though ଏକର ଏତିକି ଏତିକି belongs to the petitioners but accusation ହିଁ ଦିଆ ହବ ଆମର
there change
only khata plot area this is the change village same tahsil same district same only khata plot area khata number 10 plot number 82 of area 14
ଆପଣଙ୍କର ଲିଷ୍ଟ ନାହିଁ ଯେ ଆକ୍ୟୁଜିସନ ହେଇଛି ଆପଣ ପଇସାଟା ଆସିଲା ବୋଲି କହୁଛନ୍ତି ଆପଣଙ୍କର ଲିଷ୍ଟ ନାହିଁ।
But in the status report the acquisition of land of the petitioner has not been mentioned. Being agreed also answer to the petition number 1 acha खाली status report रे नाही but
status report ରେ ନାହିଁ ସେ କିନ୍ତୁ ଜାଗା ଯାଇଛି accordingly disburse ବି ହେଇଛି and
ଆପଣଙ୍କୁ ଡିସ୍ପୋଜ ହେଇନି ଅନ୍ୟମାନଙ୍କୁ ହେଇଛି
ନାଇଁ ଆମକୁ ଦିଆ ହେଇଛି ଯୋଉ WPC number 2 ଏ ଯୋଉ annexure 6 ରେ ଦିଆ ହେଇଛି same village mail
ସେମ ଭିଲେଜ ରେ ଆପଣଙ୍କୁ ଦିଆ ହେଇଛି କି
ନାଇଁ ସେ ଅନ୍ୟ ଲୋକମାନଙ୍କୁ ସେ ମୌଜା ସେଇଟା ବି status ରେ ନଥିଲା annexure 6 ରେ annexure 6 have a glance village ଅସଲପୁର
ସେଇ ଯୋଉ ଅର୍ଡର ଟା ଆପଣ annexure 6 ରେ ଦଉନାହାନ୍ତି ସେଟା ଶୁଣିକି କାଉଣ୍ଟର ଆଫିଡେଭିଟ ପରେ ତାପରେ ଅର୍ଡର ଟା ଫାଇଲ ହେଇଛି ପାସ୍ ହେଇଛି ହଁ
ନାଇଁ ସେଇଟା ଡିସ୍ପୋଜ ବି ଅଲରେଡି
ସେମ କେସ୍ ବୋଲି ଆମେ
ସେମ ଭିଲେଜ ସେମ ତହସିଲ ସେମ ମେଲ
ହେଲା 9th order number 9
subsequently WPC 1097 this honorable could have same village mail
କଣ ପଢିଛନ୍ତି ବୁଝିଛନ୍ତି
The amount is already compensated amount is already been deposited with the opposite
petitioner kara compensation amount has been deposited exactly that is what we are saying instead of you saying we have to say for you
तार जदि अमाउंट टा जदि डिपॉजिट हे तो किछि प्रॉब्लम नाही किंतु से इंस्ट्रक्शन मान डायरेक्ट डिस्बर्समेंट ऑर्डर टा करिबा
निजे पर कहउजन जे ताकर ना ऑर्डर रे नाही माने से लिस्ट रे नाही
स्टार्ट कारण स्टेटस रिपोर्ट रे आंकर लैंड टा एक्विजिशन हेछि बेली किछि मेंशन हेनी
स्टेटस रिपोर्ट न थाई कि भी अन्य माने पाइछन इन WPC नंबर 1097
रॉन्ग ऑर्डर जदि आ हमें सेटा फाइल करियो
नहीं रॉन्ग ऑर्डर किछि नहीं पाइ सल्लेनी आज्ञा इंक्वायरी करी कि जागा जाईची पाइ भी सल्लेनी अकॉर्डिंगली
गेट इंस्ट्रक्शन देन मैं दे दो विदाउट एक्सप्रेसिंग एनी
से जगह जाईची टमकाई पाइ सल्लेनी
attempt कर लो if the land has been of the petition of the
हां
annexure 6 टा डिस्पोज
all right will discuss
इंक्वायरी करी कि देबे आ कोन विदाउट लैंड
yes ଆପଣ ସ୍ଲିପ ରେ ଦିଅନ୍ତୁ ଆପଣଙ୍କର ଜାଗା ଫାଗା ସହିତ ତା ସହିତ
They
ଅର୍ଡର
already mentioned in WP read petition ଦିଆଯାଇଛି
ଦିଆହେଇଛି ତ
ତା number plot
ହଉ
number ଦେଇଦେବେ।
ଆସନ୍ତା ମାସ ପାଇବ ଅର୍ଡର ଟା ଦିଅ ହଉ
ଆପଣଙ୍କର ପ୍ରତ୍ୟେକ ଅର୍ଡର ରେ ଚେଞ୍ଜ କରିକି ଦିଅନ୍ତୁ ଆପଣଙ୍କର ପ୍ଲଟ ନମ୍ବର କଣ ଚେଞ୍ଜ ହବ ଇଏ ଚେଞ୍ଜ ହବ
ଆମେ ଦେଇଦେବି
ହଁ ସେଇଆ ତ କୁହାହଉଛି
ଦେଇଦେଲେ
ଆପଣଙ୍କୁ
ଟିକେ ଜଲ୍ଦି ହବ ନହେଲେ ଖୋଜି କଲା ବେଳକୁ ଡେରି ହବ ସେଥିପାଇଁ ଆପଣଙ୍କୁ ମାଗୁଛୁ ଗୋଟେ ସ୍ଲିପ ରେ ଦେଇଦିଅନ୍ତୁ
yes next
Item 21.
405 ଦେଇଦେଲେ ସେଇଟା
yes
Let the one of the building of the petitioner was acquired for the purpose of that parikrama prakalpa. And since the residual part of the building was affected by demolition, they were entitled for compensation. Land was initially recorded in the name of the petitioner's father and other co-sharers. Now, so far as the petitioner is concerned, he has two sisters. One of the sisters has executed a sale deed in favor of the petitioner and through power of attorney holder. And that is how he is claiming compensation. So far as the petitioner, he has got his payment. But the purchased property from his sister, the collector, he has applied for referring the matter to the competent authority. But the collector is not disposing of that reference application without having jurisdiction in issuing notice for the purpose of disbursement of compensation in favor of the person.
now, where is that application before the collector you say
Page 41.
page 41
Right, man. And collector is duty bound to do it within a period of 30 days from the date of application.
you have a power of attorney not you have not purchased
No, there is a sale deed. Consequent of a power of attorney, there is a sale deed. That is at page.
ମାନେ power of attorney ରେ ସେଲ୍ ଡିଡ୍ ଟା ହେଲା ତାପରେ
ହେଲା
basis of the power of attorney
right, ma'am. Page 31. There is a sale deed.
the collector has to make the reference
Collector has, because the person to whom it is payable, collector has no jurisdiction to
Right.
decide.
the authority has to decide as to under section 64
64.
so that authority is the district judge
He is a appointed on section 52.
acha district judge Cutter
No. A separate authority is appointed for that.
acha
In the cadre of district judge.
oh
ଆଚ୍ଛା
because it's a Puri land ଟା ମୁଁ ସେଇଥିପାଇଁ
The
କହୁଛି
Purita ବୋଧେ ସେଇଟା attach ହେଇଛି Cutter.
ଆପଣ ଡିସ୍ପ୍ୟୁଟ କରୁଛନ୍ତି ଯେ କାହାକୁ ଦିଆହବ
Dispute ଆମେ କରୁନୁ ଦିଆହବ ଆମେ କହୁଛୁ on the basis of sale we are entitled to compensation, but collector instead of deciding the reference application is issuing notice to all other co-sharers to decide as to whether the payment will be disbursed.
no collector has to just make a
refer.
consider also verify the matter regarding the property decide who is the person entitled to receive the check amount
Lordships are reading 64.
no I am reading 41
page 41
Acha, I'm application.
your application
in application
Right.
the notice has been issued so
he can't issue that notice. No, he cannot issue that notice. He has to make the reference. The authority has to decide it.
Right.
If he has to do all these things, then why the authority? That is why it has been made that you are just to make the reference. If you do not make the reference within the stipulated time, then he can approach directly the authority, and the authority will direct the collector to make the reference. That is there in 64.
Conversely, he is issuing notice. Conversely, he is giving notice to other co-sharers.
but Puri I think there was something else there was some
No.
committee and some-
Parikrama Prakalpa, that's not coming here. It's an acquisition process. It's beyond that 75 minutes. Beyond 75 meters, that's for land acquisition proceeding. And if your Lordship sees, I have that circular. Your Lordship is right. Your Lordships are right. That circular 2013 Act is made applicable. Achhi it was.
हाँ दोनों
I know.
that is
I have one copy, Lordship. Detach.
High Court of
Kindly see page, as is numbered page 55. Rehabilitation resettlement package
Second paragraph. To acquire the land properties falling within the zone, following the council, the formulator is over and above the company. In so on, so on, so okay. 2013.
ଏবার କଲେକ୍ଟର କଣ ଲେଖା ହେଲା କଲେକ୍ଟର ପୁରୀ will କୁଆଡେ ଗଲା
ସେଟା appropriate authority, collector ଅଛି appropriate authority, collector is
ଏଟା କଣ ସପିଂ ଇଏ ନା କଣ
ନା ଏଇଟା ଗୋଟେ ଲଜିଂ ଥିଲା ବେଲଜି ହାଉସ କଲ୍ଡ ବେଲଜି ହାଉସ
କଲେକ୍ଟର coordinate
page 58 ରେ lordship will find
58
ha serial number 3 at the top.
अच्छा
But it's got that? Yes, 58.
এটা negotiation no other provisions.
No, it's not negotiation, it's acquisition.
As the acquisition of land is being done on the basis of negotiation, it is provided that Collector Puri can finalize details.
No, it's not. In fact, it's a residual property on section.
No, no, ଆପଣ ଯୋଉ scheme ଟା ଦେଲେ
negotiation. No, it's not negotiation. ସେ property ଟାକୁ ନେଲେନି sir. Is to pass the necessary orders in terms of make the document. That has not been done. That's the short point. He cannot, either he has the power to issue notice for the purpose of deciding the entitlement. I don't think such a power is there with the collector.
whether his objection amount of reference to. So where the collector fails to make a reference to the appropriate authority,
then he has to directly approach the authority. That is, we can directly. Second approval. That collector instead issuing notice at page 43. This 64 second provision. Notice has been raised.
Land acquisition officer not the collector. Land acquisition officer for notice.
He is from collector. Land acquisition officer from collector. He is the collector.
No, land acquisition collector is somebody else.
Mr. Land acquisition officer from collector Puri, that is opposite party number 3. This application has been filed by
land acquisition officer is the collector Puri.
Kindly see annexure 1 man.
Annexure 1.
उपार्जन अधिकारी तथा जिलापाल पुरी So, madam, what do you say? Ajit got power to decide who is to. He has prayed that this notice should be quashed and it should proceed in accordance with law. That means it is to be referred to the. You take instruction though.
But short date.
Next week. All right. The petition has been filed by the petitioner Raghunath Uchikar with a prayer to quash the notice dated 18/1/2025 of the opposite party number 3, land acquisition officer cum collector Puri, and for a direction to the opposite parties to release the rehabilitation and resettlement compensation in respect of area Eckerson 012 decimal in favor of the petitioner within a stipulated date. Referring to section 64 of the 2013 Act, which is to be followed in the case as per the scheme placed by the then senior advocate Mr. Ratho. It is stated that the collector, after receiving the applications of the petitioner under Annexure 8, was supposed to refer the matter to the authority, but instead of doing the same, he has issued notice to the parties which was not within the purview of section 64. Stop. At this stage, the land council for the state wants to take instruction in the matter, put up this matter, recommencing. 17 तारीख रखी चेती तो जेम्स 17th.
I have only one request, my lord.
Yeah.
But she could see page 43. Collector has fixed the date today only for determination pursuant to that impugned notice. Let him not finally decide.
Put up
page 43, annexure 9, the penultimate paragraph.
But you are saying that that opposite party has given power of attorney.
That's right,
They
but
should
then
not
nobody
dispute.
knows what will happen before the collector. Once the collector takes a decision, then whole thing again I'll have to amend and challenge that order. Let him not finally decide that. Kindly see page 43.
No question of
Asanta 11/2 को रखी
क्षतिपूर्ण संपर्क
time. Let us see.
The final decision should not be taken as per the notice under Annexure 9 till next date. Yes. Great.
Item 22.
Yes, contempt petition. Which order has been flouted by the authority?
Annexure 1 on page 9, Your Honor.
What was the order?
Considering the made by the Udyog expressed any opinion on the merits of the case, this court dispose of the writ petition directing to opposite party number 3 to dispose of the LR case number 20 and 2011 in accordance with law.
From the date of production of the certified copy of the order.
15/5.
Give production.
25/5/24. Which has received on 24/6/24.
केते केबे
24/6/24.
24/6 रे आपण आनी देले
रिसीव करछंती
रिसीव करछंती तापरे 3 मास हेगलान किछ करनांती. You have taken that averment in your contempt petition.
Yes, sir.
You date ta katha कहबे.
Yes.
Code लिखछंती.
Paragraph 3.
So who was supposed to take a decision? पुणी अधिका लोक कर दी
दीटा पार्ट ऑर्डर अछि सेति में मु दी जन को पार्टी कर दीटा पार्ट ऑर्डर अछि
जदि हाई कोर्ट को भी पार्टी कर देबे जदि हाई कोर्ट विल नॉट टेक.
The opposite party number 2 is the competent authority.
3.
Sorry, 3.
No, for your lordship, opposite one 2.
In this contempt petition, he is opposite party number 2.
Yes, sir.
He has to carry out the order. So you take instruction. What is the status of the? Like this contempt petition has been filed by the petitioner for non-compliance of the order of this court dated 17/5/2024, passed in WPC number 12325 of 2024. So, while disposing of the aforesaid writ petition, this court has been pleased to direct the opposite party number 3, that is opposite party number 3 से case रखी है.
Your lordship, opposite party number 2, the special land acquisition officer.
That is the opposite party number 2 in this contempt proceeding. to dispose of LAR case number 29 of 2011 in accordance with law within a period of 3 months from the date of production of the certified copy of the order and to communicate the result of such exercise to the petitioner. The Land Council for the petitioner submits that the certified copy of the order was produced before the opposite party number 2 on 24/6/2024, but in spite of that, the order dated 17/5/2024 has not been carried out. Stop. The Land Council for the state seeks some time to obtain instructions regarding the status of LAR case number 29 of 2011. Court of this matter will be commencing from 24th of February. Madam, 24 तारीख में
रेस्ट सेम डेट सेम सब एका तो लास्ट वन टी अलगा
नेक्स्ट कौन अलगा ये जो 23-24 से मॉडल को जब 25 टा कौन अलगा करूछन कौन टा अलगा हो 11 में कौन ऑर्डर चाहिए
पेज 12 रे अछि ऑपरेटिंग ऑर्डर ही ना
No, just come to that page number. Mr. Behra, you come to the operative part of the item number 25 round. Having heard the Learning Council for the parties and after going through the records in the petitioner seeks direction for early disposal of the petition and so and so, this court is not inclined to grant any such direction. Our liberty is granted to the petitioner to file an application before the special LAO for early disposal of the so and so, and in case such an application is filed, the same shall be considered and disposed of in a. एतो किसी time stipulated ही नथला अदर केमती contempt आसीबो
एटा विद्रोह कर दियो कंटेम्प्ट आसी साची ओटा अंदर ना नहीं से आसीले भी एटा कंटेम्प्ट हबनी इट इज नॉट कंटेम्प्ट
this contempt petition has been filed for such and such. After going through this one, so we find that this contempt petition is not maintained accordingly.
Last contempt time is stipulated दिया है
पर जोटा रे कॉज ऑफ एक्शन नथिबो दे देले कोन हे जिवो
एगुडा तो से टाइप रो 23-24 से ऑर्डर करते हैं
आरो दिटा ठीक अछि
खाली की जोड़ी देबे सोडा ना
Here I may be partly to nothing and some. I am filing a interim application for bail. That may be taken.
The person in custody is more than 9 years, my lord.
Yes.
Supplemental list, item number 1.
May be the Lord, here there are two appellants. Appellant number 2 was earlier released, my lord. This appellant was custody since 10/8/2007. That is 17 years and 6 months.
Under the bail application of the appellant number 1 was withdrawn on 15/3/2010, then rejected on 6/3/2012, again rejected on 30/7/2014. The appellant was on interim bail
for 1 month.
13/9/2017.
Good master by
For 2 months.
कोनो 14 ବର୍ଷ ପାଖାପାଖି ସେ ରହିଲାଣି
17 ବର୍ଷ 6 ମାସ।
କଣ ପାଇଁ
पेपर रेडी है
पेपर रेडी है ତାକୁ he is still in jail.
EW1 and 5 का आइडेंटिटी होता है
म्हणजे what is the allegation? EW1 and 5 हाँ
19 पर है वो लिस्ट
देखो ये नौ तो अपील छोड़िए वो उनका इंग्लिश को वो बिल कौन दो
You have received the paperwork.
My lord, I have collected.
You have also received the paperwork. Eyewitnesses are there.
Yes.
Yes, 1 and 5.
वो 20 वर्ष ना है वैसे बेटा कंटिन्यू करना
1 and 5 and doctor is?
Doctor is 12, my lord.
What is the weapon with which you assaulted?
Weapon, my lord, falsa.
It's a sharp cutting weapon.
Yes. The person who was released, he was.
Person who was released?
He was also holding a kuradi, my lord.
But he has not dealt any blows.
Yes, that the blows are hit to the road, my lord.
मैंने he has not dealt any
His blow,
he was low, but it was not struck on the district.
There is a injury on the neck.
Yes.
That resulted in the death. Due to cut injury on the neck and severe bleeding out of trachea, esophagus, spinal cord, all the injuries are antemortem in nature, sufficient to so and so. So what is how this occurrence took place?
The motive part is concerned, there is absolutely nothing in the case record.
On the day of occurrence.
While the deceased along with the informant and PW5 were returning, my lord, in 3 motorcycles. The petitioner who was released on bail, he pulled the deceased. And when he fell down, he gave 3 to 4 blows which was struck on the road. Thereafter, my lord, it alleged that this petitioner has given 3 to 4 blows. There is absolutely no motive, absolutely silence regarding motive or earlier any cruel.
No, motive is different matter, but
absolutely nothing.
If you are given the repeated blows by a sharp cutting weapon with on the vital part of the body like so neck, and that resulted in the cause of death. So you are to bring your case to under section 304 part 1. There must be some kind of exception. What is that exception here? So when you will fail to bring your case under any of the 5 exceptions, then we cannot go to 304. So if your case squarely comes under those 4 clauses under section 300 of the IPC, then it will be culpable homicide will amount to murder. So once it goes to any of the exception, then the question of whether 304 part 1 or part 2, that would but here the blows has been found. All these blows have been given. How many blows?
1, 2, 3, 4.
3, 4 right eyebrow or 2 cut injuries, so and so. So these are the and it appears that as if you are both of you are waiting, and when they approached, one of you stopped the motorcycle.
Yes.
And
stopped the motorcycle.
He also assaulted, but Luckily, his blow did not hit that. That is the prosecution case. So this Khageshwar is the deceased. So
some witnesses have stated that suspecting him to be they heard suspecting to be a witch, so you have attacked him for that. One has of course turned hostile. PW 9. I heard that he's been murdered, suspecting him to be a witch.
You are that man who
Jayanand was granted bail.
Jayananda aiming Khageshwar dealt 3 to 4 struck on the ground, which resulted.
Petitioner Sumant.
Petitioner is accused Sumant, who is also present at the spot holding falsia. Came near Sunan saying to them on the face next also. So that is the evidence. 5 also same evidence.
Same. Both are relative brothers. All 3 are brothers.
5 has partly supported the prosecution case.
I heard the cry. So hearing, they looked back and found Suman Mera was holding falsia, assaulting so and so. Suman fell down on the ground.
Partly supported.
The blows given by that person who has been enlarged on bail, this part has not been deposed to by this PW 5. He has only stated about your assault. I was coming ahead of him near so and so. I heard the cry of so and so hearing this. So how do you support the conviction, Mr. about that man under 30234? One has totally excluded him.
No. Who has stated? Who has stated?
PW1 and petitioner.
5 has not stated.
5 not stated regarding assault of this
You see,
petition.
1 and 5 are 2 witnesses. One says the man who has been released on bail, he obstructed, pulled him. Then he also attempted to assault, but none of his blows fell on the deceased, struck on the deceased. It fell on the road. That's all right. This man thereafter assaulted him. But number 5 is another eyewitness. He has stated that I only saw this particular man who is now in custody.
Yes.
He has assaulted the deceased by means of falsia as a result of which. So he has totally excluded any attempt that has been made by the other accused who has been enlarged on bail, either obstructing or
PW5, he was ahead.
Hmm.
PW1 was backside of the deceased. They all are coming in 3 cycles. ସେ ଆଗେ ପଳେଇଛି
ଆଗେ ପଳେଇବି ସେ ଲୋକଟାର
ଚିତ୍କାର ଶୁଣିଛି
ପଛକୁ ଅନେଇଲା already
ପଛକୁ ଅନେଇଲା
ସରି ଯାଇଥିବ ସେ।
No, ତା presence କହୁନି. We are not on that. We are asking you that let us say by that time that man had already finished his assault because all the blows fell on the ground. But he was very much present there. So he should have told about his presence. So when 2 witnesses you are bringing forth to the dock and one totally excludes the presence of that. So how safe it would be to convict that person under, we are taking into account about the finality of the thing. Because we may decide this case finally, even if it is been listed for orders. So
I was at that time my brother Chittananda there.
You read PW5's evidence, there is no problem. Come to PW5.
My informant is my elder brother.
So Sumant is appellant number 1.
Yes.
And the other man is appellant number 2 is?
Jayanand Meher is appellant number 3.
Jayananda.
Yes.
Jayananda, okay. Whether this PW5, who is an eyewitness to the occurrence, has at all stated about the presence of Jayananda at this point? Again, you are telling এই जो लोक PW1 ର evidence को आउଥରେ ଆସନ୍ତୁ ପଢନ୍ତୁ।
I am the informant in this case. I know the accused person standing in the dock. I also know this is Khageshwar Meher. On 10/8/2007 afternoon, I along with Khageshwar Meher had been to Tumpada in search of labor. And while returning to our house, on the way, we meet my younger brother Chitrasan Meher.
Joel 5.
Near our village. he accompanied
That man is PW5.
Yes, Chitrasen with PW.
Yes.
he accompanied us and we were coming back in our respective cycle.
Hmm.
While Chitrasen was ahead, I
Hmm.
was in the middle and Khogeshwar was coming last. And
Khogeshwar is the deceased.
Khogeshwar is deceased.
Yes.
The accused Jayananda was standing near there holding a lanyard, stop on saying of my younger brother, Hey Jayananda.
Hmm.
In the meantime, when my younger brother crossed Jayananda, he pulled the bicycle along with Khogeshwara from his bicycle. As a result, he fell down the ground. Then Jayananda aiming Khogeshwara dealt 3 to 4 blows. He struck on the ground. Which
ଆପଣ କହୁଛନ୍ତି ଏଇ ଯୋଉ ସିଏ ଯେହେତୁ ଆଗକୁ ଟିକେ ପଳେଇଛି ଏଇ ପାର୍ଟଟା ସେ ଦେଖିନଥିବ ଏହା ତ କହୁଛନ୍ତି ତାପରେ ଲାଇନ ପର୍ସନ
which resulted breaking the handle of the axe.
Hmm.
While Khogeshwar was laying on the ground, accused Sumanta, who was also present there at that time, holding a khasa, came near Khogeshwar and on saying of Jayananda as Marmar, he assaulted Khogeshwar on his head, leg repeatedly by means of said khasa and on our intervention, both of them threatened us to do away.
So that means both of them were present. It is not that that man who obstructed the deceased, he after just giving the blows, he fled away from that place. He was very much present in the scene of the occurrence. He not only asked this appellant to assault, but thereafter also after the assault was over, he threatened the other persons.
Yes.
So in that, if that would be the case as per the PW1, how it would have gone unnoticed to PW5? PW5 would have at least said that this man was present there.
Yes.
Okay, let us forget about threatening or these things. But one who totally excludes the presence of one of the appellant who has been released on bail, how you can say that the complicity of that man has been established so as to convict him with the aid of 34 of the Indian Penal? Admittedly, he has not given the blow. His blow had not stopped. And you, out of your 2 eyewitnesses, one has totally excluded his presence. So how far this evidence of one eyewitness will be sufficient? You cannot say that, sir, leave that PW5. Don't consider PW5. We cannot do like that. Merely because it goes against you, is good against the prosecution, because he exclude the presence of appellant. We cannot exclude his version. We have to see the totality of the evidence. We have to consider PW1 and PW5's evidence. So the consistency is maintained so far as this appellant Sumant is concerned. But there is inconsistency so far as the participation of appellant number 2 is concerned. So that is the ground. And Mr. Roy, how do you get over this number of blows you have given? And what is your case now? If we accept the version of these 2 witnesses that you have dealt repeated blows by means of a sharp cutting weapon, which is corroborated by the medical evidence adduced by PW12, who has seen number of injuries are all on this neck, etc., and that is the cause of death. So how do you say that you might have been detained there? So so we are considering it finally. Just take note of it. We are considering it finally. Not going to consider your bail application. We are asking you that how can you go through that part so that these are the 2 eyewitnesses, right? Have you prepared finally for this?
You let me give 1 week or
get ready, because you get ready.
Another thing also, PW5 stated that after that he immediately out of fear returned from the spot, went to a village and narrated the incident before Ghanshyam Meher. Ghanshyam Meher madhya support schedule 2.
Yes, no strike.
By Sumant here, it is consistent by 1 and 5.
ଗୋଟେ ଆର୍ଟିଫିସିଆଲିଟି ଦେଖନ୍ତୁ ମୋ ହାତରେ ଗୋଟେ ୱେପନ ଅଛି ମୁଁ ଅଟକେଇଲି ଡିସିଜ ଆସୁଥିଲା ସାଇକେଲ ମୁଁ ତାକୁ ଅଟକେଇଲି ମୋ ହାତରେ ୱେପନ ଅଛି ମୁଁ ତାକୁ ମାରିଲି ସେ ପଡିଗଲା ତଳେ ମୁଁ ତାକୁ ମାରିଲି ମୋର କୌଣସି ବ୍ଲୋ ତା ଦେହରେ ବାଜିଲାନି ଏହା ତ ଏଭିଡେନ୍ସ ଆପେଲାଣ୍ଟ ନମ୍ବର 2 ତାପରେ ମୁଁ କହିବି ଆରେ ମୋର ତ ବ୍ଲୋ ବାଜୁନି ତୁ ମାରିଲୁ ତାକୁ ଇଜ ଇଟ୍ ଏ ବିଲିଭେବଲ ଷ୍ଟୋରି ତ ଆପଣ ଏଭିଡେନ୍ସ ହଉଛି ସେଇଆ PW1 ରେ ଯେ ତାର ବାଜିଲାନି ତାପରେ ଇଏ ତାକୁ କହିଲା ଆରକୁ ମାର ହଁ ତାପରେ ଇଏ କହିଲା ମାର ତାପରେ ଇଏ ସେଠୁ ମାରଲା ତାର ଫେସ୍ ନେଇ
Look at cross-examination of PW1 at paragraph 10. He has some ill feeling against that Jayananda.
What was seized from the spot?
Spot, my lord, the PW 13, the IO says the place of concealment of the crime weapon is near a bush at village Boipali of Hamlet Bagbu. The statement under section 27 of Evidence of Act of Actu Sumanto does not reveal that the place of concealment is at Bagbu Koda. It was an open place. It is not accessible to all. A road runs at a distance of about 30 feet from the said bush. The fact that I have seized one axe, one falsia, and a broken handle of the axe in this case. I have mentioned in the seizure list, which I seized pursuant to the statement under section 27 of the Evidence Act, that I seized a falsia.
So, alright, though this matter has been listed for hearing of the bail application, but since this criminal appeal is of the year 2009 and the land council for parties have already received the paperwork, both of them agreed for that the matter to be taken up for hearing. Place this matter will be commencing from 17th of February 2025 for hearing. Here.
Item 2.
No, in fact, your lordship was pleased to allow the interim bail application of the present appellant by order dated 28/10/2024. But my lord, he was released on bail after 1 month. That is, my lord.
So that period has not expired.
Yes. He was released on bail on 27/11/2024.
So it is likely to be over this month.
25/2/2025, sorry.
The Mr. Sahoo, Land Counsel for the appellant, submits that in pursuance of the order dated 28/10/2024 passed in IN number 9 of 2020, the petitioner was released from jail custody on
27/11/2024.
Therefore, the interim bail period has not yet expired, and the matter may be taken up in the second week of March 2025, and we will produce the surrender. This matter in the week commencing from 10th of March 2025. Yes.
Item 3.
That's it. In custody for more than 12 years.
What is this
Last
interim bail, Mr.?
pardon me.
There is
Gunshot
an-
injury.
No, there is an interim bail application.
Both are pending, but it could not be heard earlier. My earlier application was rejected on 21/10/2020.
No, so we are disposing of this
Interim because my lords, the facts are like this.
Yeah.
In the present case, I was not arrested, but in another case where I have been acquitted, but I have been encountered. So bullet was fired on my leg. So virtually one of my leg has become deformed. So that is the reason I filed this application. And I was also released on parole during Corona and all. I never misused my liberty. So that is the reason for
that chapter is now closed. We have to consider
now the main application.
That is to be considered. Like on 146 of 2021, there is an application for interim bail. Mr. Sorangil and counsel appearing for the appellant does not want to face this application. Disposed of as not placed. So this appellant is in judicial custody for how many years? You said
more than Milord's. I am taking.
You said that you have been released on parole for some time.
Sometime I have surrendered in time.
So what have you got that?
I am taken on remand on 13/9/2011.
No, have you got that custody certificate with you?
No.
That is available. Have you brought it? So get it. And number two, as Mr. Sarangi said, that he was released on parole for some time during that COVID. You obtain also instruction any kind of conduct.
Yeah. And because I have a small prayer.
Yes.
Because of that encounter, one of my leg is deformed. Even I am undergoing treatment for the last more than a decade. Present medical status is
all right. Mr. Devasi Sarangi Land Council for the appellant. IN number 1896 of 2023 submits that as per his instruction, the petitioner is in judicial custody for about
13/9/2011.
Upon COVID race, it would be more than
12 years.
More than 12 years. And he was released on parole during the COVID-19 pandemic, and he surrendered at right time. And the petitioner sustained gunshot injury in the encounter on his leg, for which he was hospitalized.
He was still undergoing treatment in the jail itself.
He is now still undergoing treatment. Let the land counsel for the you are for the informant.
I am appealing for
the land counsel for the informant is present. Let the land counsel for the state produce the custody certificate. Number one, obtain instruction about the health condition of the petitioner and also the conduct of the petitioner during parole.
Criminal antecedents.
Criminal antecedent. Criminal antecedent are there. Custody certificate and conduct during parole. So matter to be listed in the week commencing from 24th. Yes.
Both are similar.
Yes. Item number 4.
Item 4.
Madam, see the last one. Nine one. They were directed to.
Yes, yes. Yes.
It's item not so directed.
Item number 5.
Item 5 Lordship was directed to take instruction with regard to the cases antecedents of the appellant, which is there were almost 135 criminal antecedents out of which 27 were available. Rest we have to give we need some more time. Lordship may kindly allow us.
What has been case recognition? What is the offense here?
Offense, civil offenses. Lordship was directed. Second query was whether this case could have been adjudicated by the learned additional session judge Barampur, because in view of the direction of Honorable Supreme Court in Bikramjit Singh's case, special court has to try that matter. It's in Odisha. So far as the Odisha notification is concerned, on 29th April 2011, special court has been constituted by the direction of the central government, and Session Judge Khurda at Bhubaneswar has been declared as special court.
Okay.
And so far as the scheduled offense is concerned, in this case, only one offense, that is section 121 of IPC, is the schedule. All other cases are not under the schedule offense. So whether the additional session judge in the meantime has been delegated the power or not, that we need to file.
No, this judgment was pronounced under on 2019, and he has been also found guilty under section 121 IPC. So if that particular court has no jurisdiction to try an offense under 121 IPC, then how that conviction would be sustained?
Well, is that notification I found? It's all like
No, you take instruction. He is raising a point.
Yes.
So if whether this particular court is competent to try that case or not under 121, because if your case is that, what is your submission, Mr.
Exactly same. Two things besides the merit of the case. So far, mentality part is concerned, whether the concerned court who has tried the matter
whether he has the jurisdiction or not, or he has the authority, legally he is entitled for the trial or not. And second part, I also have given that the cognizance has been taken without prior sanction. All those things have to be taken up. And besides the merit partner. And as you Malad has said that regarding the criminal antecedent, as I have said, he is 135 in number. And now in the meantime, he has been acquitted in 85 cases and he has been convicted in only this case.
So as per that order 9125 order, you have to obtain instruction that
we have written letters. The Lordship kindly allows 2 weeks. I will give a comprehensive affidavit with all the cases.
so this person's list must be with the government.
Yes, I got
He's not a person who is having 135 criminal antecedent and he, according to the state, he is involved in Maoist activity. He's from that Nayagarh man.
Yes.
Like learn counsel for the state system for the time to obtain instruction in respect of other cases as well as status apart from the 27 cases on which he has received instructions. Put up this matter in the recommencing from 3rd March 2025.
Yes, we also received that custody certificate.
Custody certificate in connection with this case.
Yes,
because even if he is in custody for some other case, that would not be the date in which he was taken on remand in this case.
This
That
is the
would
first
be
case. My first case.
Oh, this is the first case.
Yeah.
Item 6.
Yeah, please. Appeal from the jail, my lord. There is a delay of 2953 days delay, my lord.
No, whether the no appeal has been earlier filed.
No, my lord. He has sent me letter, my lord. ମୁଁ ମୋର ଓକିଲ ବାବୁ ଉକ୍ତ କେସରେ ବାହାରୁ ଅପିଲ କରିବା ପାଇଁ କହିଥିଲି କିନ୍ତୁ ଓକିଲ ବାବୁ ଅଧିକ ଟଙ୍କା ମାଗିବାରୁ ଘର ଲୋକ ଅପିଲ କରିନଥିଲେ।
ଓକିଲ ସେ ଜେଲକୁ ଏମାନେ ଗୋଟେ ମନ୍ଥଲି ଯାଆନ୍ତି ମାନେ ସେସନ ଜଜଙ୍କର ଦାୟିତ୍ୱ ହଉଛି ଡିଷ୍ଟ୍ରିକ୍ଟ ଜଜଙ୍କର with ସେମାନେ ଯିବେ ସମସ୍ତଙ୍କୁ କନଭିକ୍ସନ ହେଇଛି ସେମାନେ ଅପିଲ ଫାଇଲ କଲେ କି ନାହିଁ apart from the legal aid team there is also a inspection monthly it is being done and that is also discussed in the monthly meeting ତେଣୁ ଏଇଟା କେମିତି unnoticed ହେଇଗଲା ଆପଣଙ୍କର 2014 ମସିହାରେ କହୁଛନ୍ତି we are calling for a report from the Lion Session Judge so that everything would be come to light.
Yes.
This jail criminal appeal has been received from jail late by 2953 days. From the impugned judgment, it appears that the appellant faced trial in the court of London Sessions Judge Balaswar in Sessions Trial number 48 of 2010, which arises out of Chandipur PS case number 111. 11 of 2010. Chandipur PS case number 11 of 2010. Under section 302 of the Indian Penal Code. And by judgment and order dated 21/3/2014, he was found guilty of the offense charge and sentenced to imprisonment for life. Let a report be called for from the London Session Judge Balaswar as to why immediate steps have not been taken for preferring this appeal, for preferring the in that connection also the a report be obtained from the concerned jail superintendent by the learned counsel for the state. A copy of the order put of this matter in the week commencing from 3rd of March 2025. The file be placed before the learned registered judicial who shall communicate the order to the learned session judge Baleswar for compliance. A free copy of the order be handed over to the learned counsel for the state to obtain the report from the concerned jail superintendent. Yes, next.
Item 7.
No one is there. Mohini Sahu, Vijay Lakshmi Tripathi. Vijay Lakshmi, you are.
Thereafter, original petition name is
Original petition has been received.
12/12/2024.
नहीं विजय लक्ष्मी त्रिपाठी का बदल रे आपण को एंगेज करिया
No, madam. I am appealing for the amicus curiae, madam. Thereafter, prisoner petition name is there, madam. Miss Vijay Lakshmi Tripathi.
Vijay Lakshmi Tripathi is now joined in.
Yes, ma'am. That's the
Person cannot be engaged.
Yes, ma'am.
So
That's
you
the
continue to continue.
Call for Melon 12
Oh, अच्छा.
24.
Ma'am, be allowed.
Instruction मगा ही पिला 12 वर्ष 24.
12/2024.
Yes, ma'am.
12/2024 रे कौन इंस्ट्रक्शन मंगाइतला?
Senior circle jail Barampur court instruction.
अच्छा, official communicate the order to the senior superintendent circle jail wherein the appellant has been incarcerated for his instruction and communicate the same to अच्छा आसिला की instruction.
No, nothing so that's no.
ये आपको कौन तो से सर्कल जेल बरमपुर रो कौन तो से ये हाजिर करेगा से गांधी और माधव प्रधान है ना इमीडिएटली कौन এটা 500 করুন
Item 8.
Prisoner petition filed by the appellant at flag C, praying for engagement of Mr. Deepak Ranjan Mishra in place of Saroj Kumar Padi. You have filed your V-Nama. Peruse the prisoner's petition at flag C, wherein a prayer has been made for engagement of Mr. Deepak Ranjan Mishra, advocate, in place of Mr. Saroj Kumar Padi. Mr. Mishra has filed his wakalatnama, which is accepted. The name of Mr. Saroj Kumar Padi and his associates shall not be reflected in the cause list henceforth. Stop. Yes, what about the IA?
Paper 1 is after.
You have received the deposition copies.
No, ma'am. Deposition copy. There is no deposition. Deposition copy.
Private appeal दा थिवा कथा.
हाँ, अपन पर भी नहीं. पेन ड्राइव में नहीं जा. देखो, the IA number 2124 of 20 operator लिखिए. This is an application for bail. Learned counsel for the appellant, so also the learned counsel for the state submits that they are not having the deposition copies with them, and since the trial court record has been received, the soft copy of trial court record, the office may be asked to supply the deposition copies of the witnesses in their pen drive. In view of such submission, let the registry supply the deposition copies of the witnesses examined in the trial court to the learned counsel for the both the parties in their respective pen drives. Put up this matter during course of this week करके अपन introduce कर देले. Then अपन pen drive भी ऐसी नहीं जाते. सारे गले पुनी पड़े कौन हो. तो नहीं जान तो pen drive में matter to be listed in the week commencing from 24th आसी होगा. है ना?
Item 9. Please, Your Lordship. Number the present appellate is completed offense under section 302 and 34 of IPC matter. Not fine matter is 10,000 matter.
Your bail application was never rejected earlier.
No, ma'am.
And what is the period of detention?
Period of detention matter 3 years, 10 months. Ma'am,
3 years, 10 months.
Yes, ma'am.
Why? What is the date of occurrence?
Date of occurrence 26/4 of 2021.
Acha. So please come to the judgment in paragraph number 2 of the judgment where the prosecution case has been narrated.
Yes, ma'am.
That means you are not on bail during trial.
No.
Okay.
Paragraph 2 ita padhon.
Yes, madam. It reveals from the FIR that on 26/4 of 2021, deceased Vinod Ika, who happens to be the husband of informant Jasmita Ika, had been to attend the feast in the house of one Eli Ika Tetlapada, Patwagara, on the occasion of the engagement ceremony of his son. It also reveals that after taking feast, the deceased stayed in the house of Eli Ika. It is further alleged in the FIR that on 27/4/2021 at about 10 a.m., one Benedict Ika informed the informant that someone had committed murder of her husband by assaulting with a stone. Getting information, the informant went to the Patwagara and found a dead body under a sal tree. It is specified in the FIR that as there was no one in the house of the infant, that later informed Pradeep Excess and Simita Ika, who came to the house of the informant on 28/4/2021. Thereafter, the informant lost the FIR.
So the first information report was lodged against unknown person.
Yes, ma'am.
Okay. Then is it a case of direct evidence or
Eyewitnesses there, my lord.
eyewitnesses
Yes,
are
ma'am.
there? So who are the eyewitnesses?
3 eyewitnesses there, my lord. One is PW13, another is PW17. Another one witness name in my lord, eyewitness name, my lord, one Amrit Lakra, my lord. He has charge sheet witness, but he has not been examined.
No. So far as examination is concerned,
PW13.
in the trial 13 and 17 are witnesses.
13 is first time, man.
And who is the doctor who conducted TM?
PW9, my lord.
PW9. TM doctor. Okay, let us see the eyewitness statement. PW13.
13, man.
PW13 I do not know the informant, I do not know the deceased.
PW17 would be relevant. PW17 would be relevant.
13 first time, my lord. 17 is
17 support karji.
yes, ma'am.
कौन कहला 17 पढ़े?
Page 90 of the paper.
No, it's there. Are you having those?
Yes,
Please read it out.
yes, madam. I now the informant, I now the deceased, I now the accused person standing in the dock. The occurrence took place prior to 2 years back, one day at about 11 p.m. near the hockey field of Patwagara. On the relevant day, I, along with Amrit Lakra, had been to the house of accused Johan Kispat as his guest. Again, we went to the house of English of village Patwagara, being called by accused Johan to attend the ring ceremony. At about 11 a.m., we reached the house of Eli and we took tiffin there. At evening time, we took our lunch and we also danced as there was a dance program for the third occasion. The said dance program continued till 10 to 11 p.m. on that night. After the dance program, I, along with accused Johan, Vishal, Amrit, accused Jorosan, and deceased were going towards the house of accused Johan. Accused Johan uprooted one of the wooden pole on the goal post of hockey field. The deceased and the accused Rosan were moving ahead me, Johan and Amrit. Then accused Johan dealt a blow to deceased Vinod by the said wooden pole. When the deceased was running away from the spot, accused Rosan caught hold of him and placed him on the ground. Then the accused Johan dealt 2 or 3 blows by means of a stone on the head of the deceased. At the spot, the deceased succumbed to the injuries. Then I, along with accused Johan, Amrit, went to the house of accused Johan and other 2 went to their respective houses. After one day staying at the house of accused Johan, I returned to my house. I was examined by the policeman. In cross-examination, I have come to the court today along with my parents and elder father Sati. It is not a fact that I had not stated before the police that While we were going towards the house of accused Johan, on the way, accused Johan uprooted one of the wooden poles of the whole post of hockey field, and that I had not stated about existence of a hockey field. 3 or 4 days after the occurrence, I was examined by the police. Before disclosing the matter to the police, when I was examined by him, I had not stated about it to any other person. I had accompanied my father to the said function of Ilyas, as the court felt that the witness did not understand the question again being asked. The witness stated that he had been to the house of Ilyas along with his friends and accused person. I had not gone to the spot again. When the police arrived near the dead body, Amrit and Vishal were present with me when I was examined by the police, but police examined one by one, not in presence of others. The witnesses explained that I, along with Amrit and Vishal, were in one room and police called us one by one and asked about the incident outside the said room while I was reading in the school. In case of dispute and fight among the friends, I used to convey the same to my teacher. I never disclosed assault on
No,
a
what is the ground? You are arguing a bail matter, not the merit of the case. So, as it appears, this man has stated that you have given one blow by means of a pen pole, then you dealt stone blows on the head of the deceased.
Yes, ma'am.
And it is corroborative from the evidence of PW9.
Yes, ma'am.
So the doctor has noticed that the head was completely crossed antero-posteriorly, mandible intact, bone dating from maxilla and above are crossed into pieces. Most of the areas of Swanso, so brain materials squeezed out of the skull. Few hematomas present in the inner surface of the skull. And the cause of death was due to injury to the head and brain. So that is the effect of your assault on the deceased. And you are just in custody, as you said, for 4 years.
Yes, ma'am.
So if this evidence of at least this PW 17 is believed, coupled with the evidence of PW 9, then this period is not sufficient to grant you bail in a case of this nature. There is nothing, no quarrel between you who have assaulted like that, because you have elicited in the evidence of that PW 17, the last line, paragraph number 9, cross examinations, that there was no quarrel among us while returning home. You, all of you were dancing there, right? After the dance program was over at 11 p.m., all of you are returning. Suddenly, you uprooted one wooden pole from the at hockey field goalpost and assaulted. Then you dealt stone blows on the head of the deceased.
Wooden pole, my lord, was not seized, my lord, and the stone was seized after 2 days of occurrence, my lord, and no fingerprint mark was.
No, that is, you see, whether fingerprint was available or not, that's a different matter. But
the blood stains on the stone are matching. The blood stains revealed in the stone are matching to the receipt.
My lord, I am saying some time I can take on Monday. I will prepare.
your doctor na kiye? No, that DFSL ro scientific officer PW 18 କହୁଛନ୍ତି ସେ stone ର size ବିଷୟରେ ସେ stone ଯୋଉଟା ସିଜ୍ ହେଇଥିଲା ତାର size ହଉଛି length ହଉଛି 1 feet 1 inch, breadth ହଉଛି this and height ହଉଛି ଏତିକି 9 inch ହଉଛି ତାର height, breadth ହଉଛି 11 inch and length 1 feet and 1 inch. এই ଟାଇପର ଇଏରେ ଆପଣ assault କରିଛନ୍ତି ସାଇଡରେ।
PW9 paragraph 3 ରେ କନଫର୍ମ କରୁଛନ୍ତି ଯେ ଏଇ ପ୍ରକାର ଇଞ୍ଜୁରିଟା ହେଇପାରିବ that ରତ୍ନ ପକେଜ। PW9 is the PM doctor. He confirms in the deposition in paragraph 3 that the injuries are possible by
Because it was completely crossed and that brain material that those were squeezed out of the skull. So the effect of injury was apart from that, he has examined the stone and find that there is this possible by the land counsel for the petitioner seeks for an adjournment. Adjourn program March 2025. Yes.
Item 10.
No, click closer. Item number 10. Paper book has already been read. I may be supplied with a paper book.
You have been engaged, Aziz,
Yes,
but
ma'am.
it has not yet been admitted. You don't know how they are preparing the paper. Like hard admit, paper book has already been prepared. You have received the paper book.
This is a visible ଦିଆ ହେଇଛି ଗୋଟେ ଅଧା ଜିନିଷ visible ହଉନି।
ଯାହା ପେପର ବୁକ୍ ଥିବ ଆମେ ବି ତ ସେଇଆକୁ ଦେଖିକି କରିବୁ ଦେଖି କି କରିଛି ପେପର। Item number 10. ଆପଣ ଗୋଟେ କାମ କରନ୍ତୁ ଗୋଟେ ଦେଖା ହଉଛି କିଛି ଅସୁବିଧା ନାହିଁ ସେଥିରୁ ଆର୍ଗୁମେଣ୍ଟ କରନ୍ତୁ ସେ ଯୋଉ ୱାକମ୍ ଥୁଆ ହେଇଛି ତା ଦେହରୁ ଆର୍ଗୁମେଣ୍ଟ କରନ୍ତୁ ଏଟା ବଡ କରିହବ ନାଇଁ ନାଇଁ ଏଟା ଦେଖା ହଉଛି କ୍ଲିୟର ଦେଖା ହଉଛି କେବେ ଆପଣ ପରୀକ୍ଷା କରିଥିଲେ ଚଷମା ଆରେ ନାଇଁ ସତ କଥା ଟେଷ୍ଟ ଏଭଳି ଏମିତି ନୁହେଁ ଯେ ଆପଣ ପୁରା କମ୍ପ୍ଲିଟଲି ଇଏ ଅଛି ଯଦି ବେଶୀ ଦିନ ହେଇଗଲାଣି ଯାଇ ଦେଖେଇ ଦିଅନ୍ତୁ So, you have received the paper book, madam? So the Land Council for the state submits that she has not received the copy of the paper book. Land Council for the appellant submit that she has received the paper book. Land Council for the state submit that she has not received the. Let a copy of the paper book be supplied to the Land Council for the state. And there is no interim application. It is to be added to the hearing list of matter be added to the hearing list. Yes.
Item 11.
Mrs. Mishra is not there. Now he is not Mrs. Mishra. So somebody else is to be appointed as an amicus curiae.
Let this be adjourned. I'll inform. He is coming.
Yeah. Should TCR may be called. TCR may be called. TCR may be called to the I'm sure. Appear. Let her.
If she is not interested.
Someone else maybe. Yoshma post this month to day after tomorrow. 23 years. It is coordinating with the scale fund. Can be passed. Yes, sir. Well,
Item 12.
yes, ma'am. Judgment of
How many persons case trial?
only one. Yes. Against two nine. ଦି ଜଣଙ୍କର ନାଁ ଅଛି କିନ୍ତୁ ଆଉ ତାର ପରିବାର ଅନ୍ୟାନ୍ୟ ଲୋକଙ୍କ ସହିତ ମିଶି ମୋର ବଡ ବାପା ପୁଅ ଭାଇ ଦି ଜଣ ଟାଙ୍ଗିରେ ମାରି ଦେଇଛୁ। Yes, ma'am. Yes, ma'am. ସେଟା ଆମ ଇଚ୍ଛା ପଚାରିକି ସେ କଣ ପାଇଁ ଆସି ମୁଁ ଜାଣିପାରୁଥିଲି
କହିବ ଯେ ମ୍ୟାଡମ ଏଟା ବନ୍ଦ ଅଛି କଣ
ମନ ଇଚ୍ଛା କରିବେ
ତମେ ଆସିକି କଣ ଏଠି କରିଦଉଛ
ଆମ ନଜରକୁ ଆଣିବେ ଆମେ ତାହେଲେ କରିବା ଆମେ ଇଚ୍ଛା ହେଲେ ଆମେ ଅଫ୍ କରିଦବୁ ନ ପଚାରିକି ଅନ୍ କରିପାରିବାନି ଏମିତି କହିଲା ଅନ୍ କରିବାକୁ କିଏ ନ ଯାଉ ଆମ ପାଖେ ଅଛି ଆମେ କଣ୍ଟ୍ରୋଲ କରିବୁ ତାର
So the name of the deceased is Dhiren Mandal.
Dhiren Mandal.
Just a okay.
Name of
The date of occurrence is 5th August 2005.
The FIR lodged on 6/8/2005.
Date of FIR is 6/8/2005.
Yes, sir. 9:15 a.m.
So why don't you read the FIR?
Yes,
then we'll be able. Let us know the prosecution case. Page number 27.
27.
Yes.
Mandal Pita Dhaneshwar.
Banu Singh Mandal examine ହେଇଛି?
Yes.
PW?
PW 4.
ठीक से देखिए।
PW 4.
4.
Yes.
Okay. ତାପରେ
Banu Singh Mandal Pita Dhaneshwar Mandal पोस्ट मुंडीगढ़ थाना तुमुड़ी बंध आज 6/8/2005 तारीख ସକାଳ 7 ଘଣ୍ଟା ସମୟରେ ଥାନାରେ ହାଜର ହୋଇ ରିପୋର୍ଟ ଦେବା ଏହିକି ଯେ ଗତକାଲି ରାତି ପ୍ରାୟ ରାତି ପ୍ରାୟ 8 ଘଣ୍ଟା ସମୟରେ ବିଷ୍ଣୁ ପାତ୍ର ତା ପୁଅ ସହଦେବ ପାତ୍ର ଓ ତାର ପରିବାରର ଅନ୍ୟ ଲୋକଙ୍କ ସହିତ ମିଶି ମୋର ବଡ ବାପା ପୁଅ ଭାଇ ଧୀରେନ ମଣ୍ଡଳ ପିତା ଶ୍ରୀ ଜୁଆନ ମଣ୍ଡଳ
Dhiren Mandal hochi deceased.
Yes.
Okay.
ପିତା ଜୁଆନ ମଣ୍ଡଳ ଛଚିଙ୍ଗା ନାଳ ପାଖରେ ଟାଙ୍ଗିଆରେ ହାଣି ମାରି ଦେଇଛନ୍ତି। ଏ ଖବର ମୁଁ ମୁଣ୍ଡିଗଡ ଚୌକିଦାର ଟିକ ପ୍ରଧାନୀଙ୍କ ଠାରୁ ଶୁଣିଲି।
ଟିକି ପ୍ରଧାନ କିଏ? ଟିକ ପ୍ରଧାନ
ଗ୍ରାମ ରଖି
ନାଇଁ ମ TW କଥା
TW3 madam।
TW3 ଅଛି। ହଁ ପଢନ୍ତୁ
ଯେ ବିଷ୍ଣୁ ପାତ୍ର ସ୍ତ୍ରୀ ତାକୁ ଗତ ରାତି ପ୍ରାୟ 8 ଘଣ୍ଟା ସମୟରେ କହିଲା ଉକ୍ତ ଜାଗାକୁ ଯାଇ ଧୀରେନ ମଣ୍ଡଳ ମୃତ ଅବସ୍ଥାରେ ପଡିଥିବାର ଦେଖି ଏହି ରିପୋର୍ଟ ଦେଉଛି ଏହାର ଉଚିତ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ଗ୍ରହଣ କରାଯିବ।
Okay. So in this case, is there any eyewitness to the occurrence?
Direct eyewitness ନୁହନ୍ତି।
eyewitness ଅଛନ୍ତି ନା ନାଇଁ? କିଏ କହୁଛନ୍ତି ଆମେ ଦେଖିଲୁ ଆମ ସାମ୍ନାରେ ଏମିତି ମାରଲା?
ନା ସାମ୍ନାରେ ମାରିଲା।
eyewitness ନାହାନ୍ତି ଆପଣ? ଆଚ୍ଛା, no eyewitness. So the case is based on circumstantial evidence. Mr. Naik, this is correct that there is no eyewitness to the occurrence.
So there is no such eyewitness.
ଆରେ ପଢିଛ ନା ନାଇଁ ପେପର ବୁକ୍? ମୁଁ ବୁଝିପାରୁନି ଆପଣଙ୍କର ହିୟରିଂ ଆଇଟମ ନମ୍ବର 1 and you are looking as if ମାନେ ଆପଣ ଆମକୁ କିଛି ଗୋଟେ ସରପ୍ରାଇଜିଂ ଜିନିଷ ଆମେ ଆପଣଙ୍କୁ ପଚାରିଦେଲୁ। You know that this is item number 1 hearing and it's a 302 appeal and it will be taken up. ଆପଣ ପଚାରୁଛୁ ଯେ whether it is a case of direct evidence or circumstantial evidence, you are looking as if we are posing something beyond record.
At least first 2 କି 3ଟା ଆଇଟମ ପଢିକି ଆସିବେ।
ଆପଣ ମାନଙ୍କ ଭିତରେ ଡିଷ୍ଟ୍ରିବ୍ୟୁଟ କରୁନାହାନ୍ତି କାହିଁକି? ଯେ ତୁ ମୁଁ ଗୋଟେ ପ୍ୟାଟର୍ନ ନଉଛି ଇଏ ନଉଛି, ଆପଣ କାଉନସିଲ ରେଡି ରହୁଛନ୍ତି ନା ଏପଟ ସାଇଡରୁ। All right, you proceed. So what are the circumstances? Let us say that it is a case based on circumstantial evidence. What are these? Last scene. One is last scene. All right.
Naik, sit down, but go through. Naik,
Last scene. If last scene is one of the circumstantial evidence,
yes.
Who has stated about this last scene?
PW1.
Only one witness.
Yes, the position of
1 and 2 was it?
1 and 2.
Say PW1 and 2 are the witnesses to the last scene.
Yes.
Apart from last scene, what else is there against you?
Nobody has seen.
No, Sita Gola, the direct evidence line leading to discovery, extrajudicial confession.
No extrajudicial.
Leading to discovery achi, but those first time 5 and 6.
Leading to discovery of witness. आईओ कोई थी वो?
नहीं circumstance कोड़ा कुहंतु, तापरे कुहंतु जे not proved. अब न कही रखी देले।
Leading to discovery अच्छी ना नहीं? अच्छी। What has been recovered at your instance?
X.
अच्छा।
No open field भाई।
हाँ?
Open field ठीक है।
हाँ open ठीक अच्छी। हमें आगे जानी दो जे अपन करो ना रे कौन circumstances अच्छी।
आगे।
है So these are the 2 circumstances. Okay. And what about motive?
No motive.
No motive. Now you come to the witness 1 and 2, who are the witnesses to the last scene.
Yes. The position of witness number 1. For the prosecution is at about 35.
Page number?
Page 35.
Wait.
35.
Yes, please press it.
Deposition witness number 1 for the prosecution aged about 35.
Leave it. You come to paragraph 1.
I know Dhiren Mandal, the deceased. I know the accused and his son. Deceased died about 2 years back. I was tending cattle on a piece of land of our village. Time was evening. It was much before the sunset. At that time, I saw the accused and the deceased were indulged in Patitunda. Accused's son was not seen there. The accused was holding an axe. Accused has got his land there where the aforesaid incident occurred. Next day, I heard that the deceased was lying dead near the spot where they were making gandogol. I had not gone to the spot to see the dead body. Bhakta Patra was in his land at the time of
Who is this Bhakta Patra?
Bhakta Patra.
Is he PW2?
Yes.
Yes.
Yes, madam. Bhakta Patra.
Please place the cross-examination.
My village is one and half to 2 kilometers from the deceased. From that, the deceased and the accused. Chachinganala, where I saw the incident, is inside a jungle. My village is in a jungle. I was on one side of the Nala and Viren was on the other side. I was about 400 feet away from the deceased. I did not go up to them. I cannot say who was holding what weapon and why they were creating gandogol. There is jeepable road from Chachinga to Mundigoda. It is not a fact that I am involved in the murder.
Yeah. They were quarreling, and the deceased, the appellant was holding an axe at that point of time. And on the next day, he said that the near the spot, but he had not come to the spot. Okay. Yes. So this is one item. What about this number 2? Same evidence.
Yes, madam. I know the deceased. I also know the accused and his son. Hiren, the deceased is dead. About 2 years back in rainy season, I was working in a field. It was before sunset. I saw the accused and the deceased together. I think from their gesture, they were talking. I do not know if the accused was with any weapon. Next day, I heard that the deceased was died near the spot where I had seen them together, but I did not go there to see the dead body. No one else was working with me. PW was tending cattle at nearby place.
Cross-examination.
The distance between myself and the deceased and the accused was about 400 feet. Myself and the accused belonged to one side and the deceased belonged to the another side. I was working in the field of Ratho. It is Anavadi land, but I have retained possession of that land for the last 4 years. From the field, the spot is not visible, but from the reach of the field, there where I was working, spot is visible. I came up to the bridge, but I did not come up to the spot. It is a fact that I have not stated before the IO that PW1 was then tending cattle at a nearby place because the police did not ask me about that. I have heard that Nopur Naik ex-MP is relating to the deceased. I do not know if deceased used to work for the party of which Nopur Naik is a member. The deceased used to take ganja and liquor. I can say if he had a lot of enemies. It is not a fact that I deposed falsehood by claiming that I have been accused and the deceased is together.
So if you have seen these two witnesses who have stated about the last scene, so what are your comments on this evidence of these two witnesses?
There is a gap. The dead body is received on in the next day. There is a gap.
No, the spot where both of them were seen together, the dead body was also found at that spot. That is the evidence.
But that is a jungle area. In rainy season, my lord.
No, where from the dead body was found? Who has stated? where the dead body was found?
Nobody is stated. No.
No, IO must have how because the IO came to the spot after the matter was reported.
After
And
affair lodged.
Right. After the matter was reported, he
Yes.
came to the spot, and the evidence at page number 48 of the IO's evidence, he said that I sent my staff to guard the dead body, and at 9:50 a.m. I reached at the spot and prepared the spot map.
Yes.
So, and inquest was also held over the dead body there. So, what is that spot? Exhibit 12 is the spot map. ये था देखिए ना exhibit 12 exhibit list of exhibit 12 spot map 13 ହଉଛି inquest ସେଟା
A ହଉଛି spot.
spot map ରେ ଆପଣଙ୍କର ଯୋଉଟା କି ଦେଖେଇଛନ୍ତି ସ୍ପଟ ହଉଛି land of ବାମନ ପାତ୍ର।
ବାମନ ପାତ୍ର। A.
So, Mr. Naik, you have seen the evidence of these two witnesses, 1 and 2.
1 and 2.
So, these are the two witnesses who have stated about the last scene.
Well,
one has stated that there was some quarrel between the two, which is not there in the evidence of PW2. PW2 has simply stated that from the gesture I found that they were talking.
Could not hear anything.
So, he has not stated. And so far as the weapon is concerned, one has stated that he was holding a weapon, but two says that I cannot say whether the appellant was with any weapon or not. And this is the evidence, and the place where the dead body was found. Question is that whether that is the place where both of them had seen them together or not. Because PW1 and PW2, they have seen them together at a particular spot. Dead body was found inside the jungle or in the land of so and so. Neither this PW1 nor this PW2 had gone to that spot.
They stated that I had not gone to the spot.
So it cannot be said that the place where the dead body was found is the place where both the appellant and the deceased were seen together. ଆପଣଙ୍କର ଆଇଓ ଯଦି ଏଇ ଟାଇପର ଏଭିଡେନ୍ସ ହେଲା, ଆଇଓ ତାଙ୍କୁ ନବାର ଥିଲା ଯେ ତମେ ଯୋଉ ଜାଗାରେ ଦେଖିଲ ଦି ଜଣକୁ ଖଜିଆ ହଉଥିଲା, କାରଣ ଲାଷ୍ଟ ସିନଟାର ଏଭିଡେନ୍ସ ସେଇଠି ଇମ୍ପୋର୍ଟାନ୍ସ ରଖିବ ଯୋଉଠି ଟାଇମ ଗ୍ୟାପ ସର୍ଟ ହେଇଥିବ ଲାଷ୍ଟ ସିନ୍ ଆଉ ଡେଥ୍ ଭିତରେ, ଏବଂ ପ୍ଲେସ୍ ମଧ୍ୟ କ୍ଲୋଜ ପ୍ରକ୍ସିମିଟି ହେଇଥିବ ହେଲା। ଯଦି ଆଜି ଦି ଜଣକୁ ଆପଣ ଏକାଠି ଦେଖିଲେ, ତାର 5 ଦିନ ପରେ ଜଣଙ୍କର ଡେଡ୍ ବଡି ଆଉ ଗୋଟେ ଜାଗାରୁ ମିଳିଲା, so no importance can be given to that evidence because there is chance of any other person like third person coming in contact with the deceased in the meantime. So you are to rule out the deceased coming in contact with any other person. ତେଣୁ ଏଠି ଗୋଟେ ବାହାର ଜାଗାରେ ଦିଟା ୱିଟନେସ୍ କହୁଛନ୍ତି ଆମେ ଦେଖିଲୁ ଦି ଜଣକୁ ସେମାନେ ଜଣେ କହୁଛି ପାଟିତୁଣ୍ଡ କରୁଥିଲେ ଆଉ ଜଣେ କହୁଛନ୍ତି ଆମେ ସେଠି ଛିଡା ହେଇଥିଲୁ ତାପରେ ଆପଣ କହୁଛନ୍ତି ଯେ ସେ ଡେଡ ବଡିଟା ଗୋଟେ ଜାଗାରୁ ମିଳିଲା ହେଲା ସେଇ ଡେଡ ବଡି ଯୋଉ ଜାଗାରୁ ମିଳିଲା whether that is the place where both of them seen together କାହିଁକି ନା ଆପଣଙ୍କର ସ୍ପଟ ମ୍ୟାପ କହୁଛି ଯେ spot is the land of Baman Patra. There is nothing in the evidence of PW1 and PW2 that they had seen them together in the land of Baman Patra.
And the PW3 only saying that the accused wife has come to my house and told that her husband has.
No, accused wife is not a witness to the occurrence. We do not know how she stated, and it is be hearsay evidence.
Yes, evidence.
Once you do not examine that one, he sees not, see, he କହିଦେଲା ଆସିକିନି that is not the evidence. ତେଣୁ accused wife ଆସି ତାକୁ କହିଲା ଯେ ମୋ ସ୍ୱାମୀ ହାଣି ଦେଇଛି ତ what is the source of knowledge? ତା ସ୍ୱାମୀ ତାକୁ କହିଥିଲା ସେ ଆଟଲିଷ୍ଟ ତାକୁ ଏକ୍ସାମିନ କରିଥିଲେ ସେ ଯଦି କହିଥାନ୍ତା ଯେ ହଁ ମୋ ସ୍ୱାମୀ ମତେ ଆସି କହିଲେ ଯେ ମୁଁ ଆକୁ ମାରି ଦେଇଛି ତାପରେ ମୁଁ ଯାଇକିନି PW3 କୁ କହିବି then it would be admissible. Otherwise this type of evidence would be hearsay evidence. ମତେ ତା ସ୍ତ୍ରୀ ଆସି କହିଦେଲା ମୁଁ ଅମକଠୁ ଲୋକଙ୍କଠୁ ଶୁଣିଲି. These are all hearsay evidence.
So far the medical report is concerned with the PW9. They are stating that on laceratory injury 6 into 3 into 8 cm over the left side of the parental region, fracture of skull over left side of
PW9 the evidence ରୁ ଆପଣ କହୁଛନ୍ତି homicidal death is established. She is not disputing that. Neither the prosecution case that it is a homicidal death is disputed by the learned counsel for the appellant, nor let us say it has remained unchallenged. The evidence is, question is that who has caused that. It's a case of circumstantial evidence. And if that evidence lasts in ଗୋଟେ ଅଛି ଆଉ ଗୋଟେ ହଉଛି ଆପଣଙ୍କର leading to discovery. Leading to discovery ର ଯୋଉ ଦିଟା witness independent witness ଦେଇଥିଲେ they have not supported the prosecution case.
5.6.
Who are those two witnesses?
5.6.
PW5 and PW6.
Yes.
Independent witnesses. Not supported the factum of seizure of axe at the instance of the appellant. All right. So the only evidence remains is that of the IO. Right? So one axe is seized. So unless you prove that that axe is the weapon of offense that was used for commission of the crime, then that recovery becomes immaterial. Yes. Mr. Mahanti, in this case, there is no direct evidence. It's a case based on circumstantial evidence. Circumstances are mainly two circumstances are there. You have not proved any motive behind the crime, which is one of the essential things which is to be required to be proved, because in direct evidence case, no motive is required to be proved. Circumstantial evidence, the motive has its own significance. Now you are proving one last scene, which is deposed to by PW1 and 2. Another is leading to discovery of an axe. So far as leading to discovery of axe is concerned, two witnesses, independent witnesses, they are PW5 and 6, they have not supported the prosecution case. Only the IO's version is there. So far as last scene is concerned, The PW1 has stated that I saw both of them quarreling at a particular place, and this appellant was holding an axe, right?
Cross-examination.
And PW2 has also seen them, but he has not stated that they were quarreling. He stated that from the gesture, I found that they were talking. And she has not also stated that he has seen the weapon with certainty. ତେଣୁ ବାକି ରହିଲା ଯେ ଯୋଉ ପ୍ଲେସ ରେ ଆପଣ ସେ ଦି ଜଣକୁ ଦେଖିଛନ୍ତି ସେଇ ପ୍ଲେସ ରେ ଡେଡ ବଡି ପଡିଥିଲା ବୋଲି ଏମିତି କିଛି ଏଭିଡେନ୍ସ ନାହିଁ no, the spot which has been shown in the spot map is the land of one cultivated Bamana Patra. ବାମନ ପାତ୍ର ଜମିଟା ହଉଛି ସ୍ପଟ ବୋଲି ଆପଣ ସ୍ପଟ ମ୍ୟାପ ରୁ ଦେଖିଛନ୍ତି କାରଣ ସେଇଠି ହିଁ ଡେଡ ବଡି ପଡିଥିଲା ତ ଏଇ ଦିଟା ୱିଟନେସ କେହି ସେ ଜାଗାକୁ ଆସିନାହାନ୍ତି ଏକ ଆସିନି କି ଦୁଇ ଆସିନି ତାଙ୍କ ଏଭିଡେନ୍ସ ଚିଫ ଏକ୍ସାମିନେସନ ଅଛି ହେଲା ସେମାନେ ଆସିନାହାନ୍ତି କି ପୁଲିସକୁ ପଏଣ୍ଟ ଆଉଟ କରିନାହାନ୍ତି ଯେ ଆମେ ଏଇ ଜାଗାରେ ସେ ଦି ଜଣକୁ ଦେଖିଥିଲୁ ଆପେଲାଣ୍ଟ କୁ ଆଉ ଇଏ ଡିସିଜ କୁ ଦେଖିଥିଲୁ ତେଣୁ या जदि एविडेंस हला आपनकर आउ सर्कमस्टेंशियल एविडेंस रो जो प्रिंसिपल रहूची हाउ कैन यू से दैट द चेन हैज बीन कंप्लीट absence of motive there is no proof of motive last seen evidence is this and one recovery of the arts and at the instance of the appellant which is deposed to by IU only no other witness so how can you sustain a charge under 302?
One is for the active was what is done there were the applicable
हाँ पढ़ुनाहांती आपण
Because I saw the accused and the decision involved in the particular, accused son was not seen there. The accused was holding that accused had got to the land there where the appropriate incident occurred. Next day, I heard the decision was laying dead near the spot.
No, he had that. But next line is very important. I had not gone to the spot to see the dead body. ହେଲା ତେଣୁ ସିଏ ସେ ଜାଗାକୁ ଆସିନି କି ପୋଲିସକୁ ସେ ଜାଗା ଦେଖେଇନି ହେଲା ତେଣୁ ଲାଷ୍ଟ ସିନ୍ କୁ କୋରିଲେଟ କରିବାକୁ ହେଲେ ଯେ ଏଇ ଜାଗାରେ ସେମାନେ ଦେଖେଇଲେ ଡେଡ ବଡିଟା ଏଇଠି ମିଳିଲା ମ୍ୟାଟର ଇଜ ଡିଫରେଣ୍ଟ ତେଣୁ ଆପଣ ଦି ଜଣକୁ ଦେଖିଲେ ଗୋଟେ ସମୟରେ ଡେଡ ବଡି ତା ପରଦିନ ମିଳୁଛି ନା ତା ପରଦିନ ଗୋଟେ ଜଙ୍ଗଲ ଭିତରୁ ମିଳୁଛି ଡେଡ ବଡି ତେଣୁ ହାଉ କ୍ୟାନ୍ ଦ୍ୟାଟ୍ ବି ୟୁଟିଲାଇଜଡ ଆଜ ଏ ଲାଷ୍ଟ ସିନ୍ ଆଉ ଏଇ ଯୋଉ ଚିଫ ଏକ୍ସାମିନେସନ ଏଇ ଯୋଉ ଲାଇନ ଟା କହିଲା ନା ଯୋଉ ସେ ଗୋଟେ ଆକ୍ସ ଧରିଥିଲା ବୋଲି PW1 now you see in the cross examination I cannot say who was holding what weapon when they were creating gandobal ତେଣୁ ଚିଫ ରେ କହୁଛି ସିଏ ଧରିଥିଲା ଆକ୍ସ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ କହୁଛି ଯେ କିଏ କଣ ଓପନ ଧରିଥିଲା ମୁଁ କହିପାରିବିନି କାରଣ ମୁଁ 400 ଫୁଟ ଦୂରରେ ଥିଲି ଡିସିଜ ଟୁ ମୁଁ ତାଙ୍କ ପାଖକୁ ଯାଇନି ତେଣୁ ଏଇଆ ହଉଛି ଏଭିଡେନ୍ସ what are these other witnesses PW3 ଛାଡନ୍ତୁ ସେ କହିବାକୁ କହିଲା ତାର ସ୍ତ୍ରୀ କଣ କହିଲା what about PW4 PW5 6 ତ hostile
I know the accused and the deceased. Hiren is my elder brother's son. About 2 years back, the deceased died on 6/8/2005 at 7 a.m. I first come to know from PW3 that accused Vishnu's wife told him that her husband had murdered.
ये ताकू ता स्त्री ताकू कहला PW3 को PW3 आकू कहला तापरे
Tapre wife told him husband and murdered the deceased near Chachinganara. Myself and other went to see the dead body. Then I went to the police station to file a FIR. PW3 had also accompanied me. Exhibit 1 is the FIR. Exhibit 1 by 1 is my signature.
एटा होची देखंदु ई होची एतलागारी या पाखरे आसिकिनी PW3 कहूची हला जे मते अक्यूज्ड स्त्री कहिला जे अक्यूज ता जो डिसीज को मर्डर करची तापरे लोक एया जानी किने आसिला एतला दवा जदि सेया हेइथांता ताले एतला रे लिखि थांता हमें तांग स्त्री कोटू खबर पाइलु हैला से लिखिची कोन ना विष्णु पात्र तार पुओ सहदेव पात्र एवं तार परिवार अन्यान्य लोक मानक सहित मिसी मोर अम्मकू मार देइछन्ति so certainly this information which these witnesses have stated that they received from the wife of the accused prior to the lodging of the FIR, that is not acceptable. Otherwise, it would have been there in that FIR itself. FIR रे माने 4-5 जन को लोक माने विष्णु सहदेव तापरे फैमिली मेंबर्स समस्त को कहछि समस्ते तांकू मिसी छाड़िंगे नाଳ पाखरे टांगिया रे मारी आनी देइछन्ति That's all. सेटा कोन हो ताको से सिथरे कोन P02 रे कन्विक्शन करियो कि गोटे आईओ नै किनी गोटे बाहर करी आईओ से देला टांगियाटा से टांगिया से एविडेंस रे unless you prove it to have been acha another thing you see suppose this PW1 has seen the tangia in the hands of the appellant. So the prosecutor's duty is to show that MO1 से टांगिया टा को PW1 को देखिवार थिला जे बाबू देखिलो तमे जो टांगिया टा कहउथिलो ये एटा होची सेही टांगिया सेटा तो पचारना से टांगिया प्रमाण ही अरे the tangia is the weapon of offense and this tangia has been marked as MO4.
Yes.
It is by the IO छड़ा vital witness आपनकर किए थिला PW1 ना PW1 कहूची जे appellant हाथ रे मु देखिथिली टांगिया जेतेबेले appellant डिसीज सहित करी करथला तेणु सेतेबेले prosecutor ड्यूटी नथिला ताकू देखिबा को बाबू जो टांगिया तमे देखिथिलो तमे चिन्ही पारिबो कि नाही से कहिथांता हां तापरे देखिथांत ए टांगिया से कहिथान हां मार्क हिथांता एमओ तोडा किछि हेनी तो हाउ डू यू एस्टैब्लिश that this very tangia which was your weapon of offense was in the hands of the appellant when he was last seen with the deceased on the date of occurrence? Nine. So the chains are missing. The chain it should be a complete chain. So complete chain ro link miss kale आपनकर circumstantial evidence ro case fail हे Take down. JCRL number 21 of 2008. Your name is to be reflected. Yes, Mr. Naik. हाँ हाँ अच्छा ओ तापर हमें डाकिया बोल अच्छा केस को आइटम दा हेडा इतना 7
କରିଦେଲେ ବି ହୁଅନ୍ତା ସେଟା ସେ ଯୋଉ ଜେଲରୁ appear ହଉଥିଲା ସେ
हाँ
ଡାକିବାକୁ ଟାଇମ୍ ଲାଗିବ ନା।
कहीं पड़ा ताकू कौन कहउछन ताकू से जेल कथा कौन से अपियर करियो का बरमपुर कौन जॉइन करियो
ପାସୱାର୍ଡ ବୁଝିପାରିବେନି ଆପଣ ଆଇଟମ ନମ୍ବର ଟା ଦେଖନ୍ତୁ ପଚାରନ୍ତୁ କିଏ ଅପିୟର କରୁଛି।
ବ୍ରହ୍ମପୁର ଜିଲ୍ଲା
ବ୍ରହ୍ମପୁର ଜେଲ୍ ଅନମ୍ୟୁଟ କରନ୍ତୁ।
ସିନିୟର ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଅଛନ୍ତି ସାବାସ।
सबसे सामना कौन है अच्छा से
माधव प्रधान गांधी
गांधी ना गांधी कौन आलियास माधव प्रधान कुआडे गले सी कहीं बस हाँ आगु आसतु आपणकर जो हाईकोर्ट रे वर्तमान गोटे अपील दाखल करछंती जो आपन को आजीवन कारादंड हेची हत्या मुकदमा रे सेति पई आपन गोटे जेल रु गोटे दरखास्त देइथिले जे विजय लक्ष्मी त्रिपाठी को आपनकर वकील हिसाब रे नियुक्ति करा जाओ एवं विजय लक्ष्मी त्रिपाठी मध्य दाखल करथिले वकालतनामा वर्तमान विजय लक्ष्मी त्रिपाठी सरकारी वकील हो गलेनी तेणु सी आ केस परिचालना करि परिबे नाही तेणु वकील आमे मोहिनी साहू जने एडवोकेट मैडम आपन को सामना रे अछंती तो तांकू एंगेज करथिलु ए केस को करिबा पई तेबे आपण अन्य कहा को चाहुचंती ना सेही मोहिनी साहू आपनकर केस करिवे ना कोन करिवे कोन सेहि पे हमें आपन कहलु
आज्ञा मोहन साहू
करिवे अच्छा ठीक है सो यू आर
गोटे अपेलेंट तो
गोटे
ठीक अछि
लेखो
आज्ञा आज्ञा मोहन साहू फोन नंबर किछि
हाँ आमे से आपण जेल को संगे कथा हे जिवो तांग संगे से आपण संगे सुदा कांटेक्ट रखिवे
अच्छा हो ठीक है से जेल रो नंबर दे देबे जदि कोन किछि कंसल्टेशन दरकार थिवो इंस्ट्रक्शन किछि नबार थिवो से जेल को फोन कले जेल सुपरिटेंडेंट आनिबे तांको प्रेजेंस रे जा केस विषय रे जा
आपण
पचारे
सुपरिटेंडेंट को तांका नंबर ता दे देले से कथा हे
हला आपनकर जदि मैडम आपनकर फाइल पढ़ी सारला परे केस विषय रे किछि डिस्कशन करिया को भाबंती ताले जेल सुपरिटेंडेंट को आपन को फोन कले से आनिकिनी आपन संगे जोगाजोग करिवे जहा पचारिवा कथा पचारिवे आपन को मध्य जेतेबेले जदि चाहिबे मध्य नंबर मध्य आपन को जोगी दिया जीवो मैडम करो से जेल सुपरिटेंडेंट को फोन रु फोन करी कथा वार्ता हे जिवे जहा आपन केस विषय मैडम को कहियार अछि कहबे ठीक अछि
आज आपण नंबर ता दिया हे जिवो सरकारी वकील दे देबे जेल सुपरिटेंडेंट को हला दे देबे आपण
दी ना कोन तो गांधी alias माधव प्रधान appeared through virtual mode from who jail अछंदी circle jail Berhampur earlier he had filed a prisoner's petition requesting Miss Vijayalakshmi Tripathi to conduct the appeal preferred by him but since Ms. Tripathi has now in the government panel and this court engaged Ms. Mohini Sahu as the learned amicus curiae. We asked the appellant as to
मोहिनी साहू को बदे मजा हम के आगु एंगेज करथिलु तापर से ताको देइथिला मोहिनी साहू स्टिल
अच्छा this court had already engaged Mohini Sahu as the learned amicus curiae to assist the court by the order dated 21/5/2024. When we asked the appellant as to whether he has got any objection if Ms. Mohini Shah conduct this appeal, he stated that he has no objection. You have received the paper book.
Yes, my lord.
Ms. Mohini Shah has already received the paper book and he seeks some time to prepare for this case. The name of Miss Vijayalakshmi Tripathi shall not be reflected in the cause list henceforth. All right.
May I submit one thing? The Supreme Court judgment that life convict the 10 years practice.
नहीं अपन ही नहीं थे
अरे that is a problem.
अच्छा ଶୁଣନ୍ତୁ
ମାଧବ ବାବୁ
ଆଉ ଗୋଟେ କଥା ଆମେ ଭୁଲିଗଲୁ ଯଦିଓ କୋର୍ଟ ଏନଗେଜ କରିଛନ୍ତି ମିସ୍ ମୋହିନୀ ସାହୁଙ୍କୁ କିନ୍ତୁ ଅନେବଲ ସୁପ୍ରିମ କୋର୍ଟଙ୍କର ଯୋଉ ଅଛି ନିର୍ଦ୍ଦେଶ ଯେ ଯିଏ ଆଡଭୋକେଟ ଯାହାଙ୍କର 10 ବର୍ଷ ମିନିମମ୍ ପ୍ରାକ୍ଟିସ ଥିବ ସେଇଭଳି ଜଣେ ଓକିଲ ହିଁ ଲାଇଫ ଇମ୍ପ୍ରିଜନମେଣ୍ଟ ବା ଡେଥ ସେଣ୍ଟେନ୍ସ କେସ୍ ହିଁ କରିପାରିବ ତେଣୁ ଆମେ ଆମାଇକ ସ୍କ୍ୟୁରି ଯୋଉ ଏନଗେଜ କରିଥିଲୁ ସେଟା କରିପାରିବୁନି ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି ମୋହିନୀ ସାହୁଙ୍କୁ ଏନଗେଜ କରିବା ପାଇଁ ଆପଣଙ୍କ କେସରେ ତାହେଲେ ଓକିଲାତନାମା ଗୋଟେ ପଠେଇଥିଲେ ସେ ଆପିୟର କରିପାରିବେ ଆପଣଙ୍କ ପାଇଁ ବୁଝିପାରିଲେ ନା ଆମେ ଯୋଉ କୋର୍ଟ ଗୋଟେ ଅର୍ଡର କରିଥିଲେ ମୋହିନୀ ସାହୁଙ୍କୁ ଏନଗେଜ କରିବା ପାଇଁ ସେଇଟା ଯେହେତୁ ତାଙ୍କର 10 ବର୍ଷର ପ୍ରାକ୍ଟିସ ନାହିଁ ତେଣୁ ସେମିତି କରିପାରିବନି ଆପଣ କିନ୍ତୁ ଚାହିଁଲେ ତାଙ୍କୁ ଏନଗେଜ କରିପାରିବେ ଅର୍ଥାତ ଆପଣ ଚାହିଁଲେ ଯିଏ ବର୍ଷେ ବି ପ୍ରାକ୍ଟିସ କରିଥିବ ତାଙ୍କୁ ବି ଆପଣ କହିପାରିବେ ନିଜର ଓକିଲ ରଖିପାରିବେ କିନ୍ତୁ ତା ପାଇଁ ହେଲେ ଆପଣଙ୍କୁ ମୋହିନୀ ସାହୁଙ୍କ ନାଁରେ ଗୋଟେ ଓକିଲାତନାମା ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟଙ୍କ ଜରିଆରେ ପଠେଇଲେ ସେ ଆପଣଙ୍କ ପାଇଁ କରିଦେଇ ପାରିବେ କଣ କହୁଛନ୍ତି ପଠେଇବେ ଓକିଲାତନାମା
କେତେ ବର୍ଷ ହେଇଛି ମ୍ୟାଡାମ ଆପଣଙ୍କର 5 years
ପଠେଇବେ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟ କିଏ ଅଛନ୍ତି ପାଖରେ
ଆମେ ଆଉ ଗୋଟେ ଡେଟ୍ ରଖିବା ସେ କଥା ହେଇକି ନହେଲେ ଜଣାନ୍ତୁ ଇଏ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ନଥିବେ ଆଉ କିଏ
ଆଚ୍ଛା
ଜାଣିବେ
ତ ଆପଣ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟଙ୍କ ସାଙ୍ଗରେ କଥା ହୁଅନ୍ତୁ ଆଉ ଯଦି ମନ ସ୍ଥିର କରୁଛନ୍ତି ଯେ ମୋହିନୀ ସାହୁଙ୍କୁ ଦବାକୁ ଆପଣ ଚାହୁଁଛନ୍ତି ତାହେଲେ ଆପଣ ଓକିଲାତନାମାଟା ଲେଖିକିନି ଆଉ ଗୋଟେ ଦରଖାସ୍ତ ଦେଇ ଦିଅନ୍ତୁ ହେଲା ତାହେଲେ ମୋହିନୀ ସାହୁ ଏନଗେଜ ହେଇଯିବେ ଆପଣଙ୍କ ପାଇଁ କରିଦେବେ ବୁଝିପାରିଲେ କି ଆପଣ ତାକୁ ବି ନ କରିବାକୁ ଚାହିଁବେ ତାହେଲେ କୋର୍ଟ ଆଉ ଜଣକୁ ଏନଗେଜ କରିବେ ଯାହାର ପ୍ରାକ୍ଟିସ 10 ବର୍ଷ ଥିବ ତାଙ୍କର ଗୋଟେ ପ୍ୟାନେଲ ଅଛି ଆମର ଲିଷ୍ଟ ଅଛି ଯୋଉମାନେ 10 ବର୍ଷରୁ ଉର୍ଦ୍ଧ୍ୱ ପ୍ରାକ୍ଟିସ ଅଛନ୍ତି କ୍ରିମିନାଲ ସାଇଡରେ ପ୍ରାକ୍ଟିସ କରୁଛନ୍ତି ତାଙ୍କର ଗୋଟେ ଲିଷ୍ଟ ଅଛି ତାଙ୍କ ଭିତରୁ କାହାକୁ ଜଣେ ଭଲ ଆଡଭୋକେଟକୁ ମଧ୍ୟ କୋର୍ଟ କରିଦେଇ ପାରିବେ
ଲିଗାଲ ଏଡ୍ ତରଫରୁ ଦେଲେ ଆପଣ ତାଙ୍କୁ କିଛି ଫିସ୍ ଦବାକୁ ପଡିବନି ଆପଣ ଯଦି ନିଜ ଓକିଲ ଆଉ କାହାକୁ ରଖିବେ ତାହେଲେ ଫିସ୍ ଦବାକୁ ପଡିବ ତ ଆପଣ ଯଦି ଆମକୁ କହିବେ ଆମେ ସେଇ ଲିଷ୍ଟରୁ ଦେଖିକି ଯାହାର 10 ବର୍ଷ ପ୍ରାକ୍ଟିସ ଥିବ ଯେକୌଣସି ଜଣେ ଓକିଲଙ୍କୁ ଦେଇପାରିବୁ ତ ଭାବିକି କୁହନ୍ତୁ ଏବେ କହିବେ ନା ଆଉ ଦିନକୁ ରଖିବେ ଆପଣ ଭାବିକି କହିବେ କଣ କହୁଛନ୍ତି
ଦିଅନ୍ତୁ 10 ବର୍ଷ ପ୍ରାକ୍ଟିସ
ଗୋଟେ ଜଣେ ଦେଇଦବା ତ ହଉ ଠିକ ଅଛି ଠିକ ଅଛି ଲିଷ୍ଟଟା ଅଛି କି ଦେଲେ
ଜଣେଇଦେବ ତ ପୁରା ସାମ୍ନା
ହଁ ଜଣେଇକି ନାଁଟା କହିଦବୁ ସୋ ଦ୍ୟାଟ ଆପଣଙ୍କୁ ଫୋନ ନମ୍ବର ମିଳିବ ଲିଷ୍ଟ ଦିଅନ୍ତୁ ଲିଷ୍ଟ କଣ ନାହିଁ ମ ଲିଷ୍ଟଟା ଦିଅନ୍ତୁ ଆପଣ ଆପଏଣ୍ଟ କରିବେ ନା କଣ ଆଉ ତାହେଲେ କମ୍ପ୍ୟୁଟରରେ ରଖିଦେଲେ ହବ ଚଳିବ ସେ କମ୍ପ୍ୟୁଟରରେ ଆମର ଯିବେ ତାଙ୍କର ସରିବ କାମ, ନହେଲେ ପୁଣି ଆଉ ଜଣେ ଲିଷ୍ଟ ହବ, ସେ ଆଉ ଜଣେ ମାଗିବେ। 10 ବର୍ଷ ହେଲା ତ। ସବୁ ଦୋଷ।
Alright. Court engage କରୁଛନ୍ତି ମିଷ୍ଟର ଅମିତାଭ ତ୍ରିପାଠୀଙ୍କୁ ଆପଣଙ୍କ ପାଇଁ ହେଲା, ଯାହାଙ୍କର 24 ବର୍ଷ ପ୍ରାକ୍ଟିସ ହେଲାଣି, କ୍ରିମିନାଲ ସାଇଡରେ ପ୍ରାକ୍ଟିସ କରୁଛନ୍ତି, ତାଙ୍କୁ ଏନଗେଜ କରୁଛନ୍ତି ହେଲା। ଆଉ ତାଙ୍କର ଫୋନ ନମ୍ବର ଆପଣଙ୍କୁ ଦିଆ ହେଇଯିବ, ଆପଣଙ୍କୁ ମଧ୍ୟ ଆପଣଙ୍କର ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟଙ୍କ ନମ୍ବର ଦିଆଯିବ ଅମିତାଭ ତ୍ରିପାଠୀଙ୍କୁ, ସେ ଆପଣଙ୍କୁ କଣ୍ଟାକ୍ଟ କରିବେ ହେଲା। ତ କଣ ଲେଖିଲେ ପଢିଲେ ମୂଳରୁ ପଢନ୍ତୁ। Yes. The appellant level. Appellant, prisoner's petition, नहीं सेटू सेटा लिखंतु earlier अच्छा earlier this court has engaged सेटा मु डाकिथिली परा हां सेटा पढना दी वाला कोड वाला से हां
ସେଟା ଛାଡ଼ ସିନ୍ସ
तापर लिखंतु सेट लिखंतु since Miss Mohini Sahu is not having a practice of 10 years, we disengage her from being to act as the amicus curiae.
As the appellant wants us to engage a counsel on his behalf.
From the we told the appellant that has he got any objection if we engage a counsel from the panel lawyers of this High Court Legal Services Committee. The answer was in negative, and accordingly we engaged Mr. Amitabh Tripathi, who is having practice of 24 years in the criminal law, to be the amicus curiae for the appellant.
It's going to legal aid counsel.
As the legal aid counsel for the appellant. The appellant was apprised about the same, and a copy of the paper book, which has been received by Miss Mohini Sahu be returned to the court master, who will hand over the copy to Mr. Amitabh Tripathi. And the land counsel for the state shall instruct the jail superintendent to send the wakalatnama of the appellant, so that it would be filed by Mr. Amitabh Tripathi. A free copy of the order be handed over to the land counsel for the state for compliance. तो आज आम ऑर्डर करू अमिताभ त्रिपाठी आपणकर एडवोकेट हिसाब रे आमे तांकू नियुक्ति देलु एवं आपणकू जेल रु गोटे वकिलातनामा पठेले अमिताभ त्रिपाठी तादेरे दस्तखत करी एटी फाइल हबो हला
फोन नंबर
तो
दिया है
फोन नंबर आपनकू दिया है जीवो अमिताभ त्रिपाठी को संगरे जितेबेले भी कथबार्ता हबाक चाहिए जेल सुपरिटेंडेंट जरिया रे कथबार्ता हेबे तांकर मध्य आपनकू संगरे जोगाजोग करिया हेले से आपनकू जोगाजोग करिवे हला the name of Mr. Amitabh Tripathi shall be reflected in the cause list henceforth है ना ठीक
I have already written the paperwork.
he has written she has written the paperwork so we'll call the declare the judgment tomorrow in open court है ना लिस्ट करिए आइटम नंबर 1 में चिपका दीजिए है ना करिए